Welcome to the regularly scheduled meeting of the Compliance and Amendments Committee of the Sunshine Ordinance Task Force. It is 4 o'clock on Tuesday, July 12th, 2011. Mr. Clerk, would you call the first item, please?
Madam Chair, roll call first.
Roll call first, please.
Member Snyder? Snyder present. Member Nee? Nee present. Member Washburn?
Here.
Washburn present. Member Wolf? Wolf absent. Member Johnson? Here. Johnson present. Madam Chair, we have a quorum.
Member Nee?
Yes.
Mr. Clerk, I'm wondering if you've heard from Member Wolf regarding whether he would be here today?
He did not mention anything, Mr.
Okay. I'm going to turn my cell phone on because sometimes when he is later en route, he will call me or text me on my cell phone. So I'm going to see if he's left any messages on my cell phone, and if you'll bear with me, it should take just a second. Okay, my cell phone is showing no messages, so we can assume that Member Wolf is en route.
Oh,
Speaking
and
of,
he is.
We haven't volunteered you for anything, Member Wolf, but we're still glad you're here.
We're just on the verge of For what, though?
We're still working on the list.
That's right.
Okay. Now, let's have the first item on the agenda. Mr. Clerk?
Item number 1 is the approval of March 8, 2011 regular meeting minutes.
I have one small edit.
We should move it.
Okay, we said first. Okay.
I moved them.
Second.
All right, I have on page 2 of the packet, or page 2 of the minutes, page 6 of the packet, in the middle of the page, it's the motion by Member Nee, seconded by Member Wolf. The word non-compliance should either be one word or hyphenated. Member Wolf?
Yes, I would, as per some of our discussions with the clerk, I would like to have the timestamps of the audio for each item be placed in the minutes.
Member Johnson?
Am I on? There are a couple of things. I had wanted to listen to the public comment, so I went back and listened to public comment again since we were having trouble with our action minutes. And there's a couple things on page 2 of the minutes, page 6 of the packet. In public comment, Mr. Piccarello actually said that he found the document to be legally unsustainable as opposed to sustainable. And then on the next page, page 3 of the minutes and page 7 of the packet, there's on item 7, it is true that Member Wolf suggested that the order of termination be officially attached to the minutes, but I don't know what that none is at the end. And then, so the public comment on item 6, public comment, says Alan Grossman spoke against action minutes. And you know, I just think that's it's too vague. And he actually read from 67.16 the requirements for the minutes for public comment and discussed that 7 sets of our minutes were backed up. So I think it would be good if it reflected just a little bit more detailed than he just spoke against the action minutes. He made some pretty specific reasons that we could go back and use. And then it says Thomas Pigarella spoke on the task force in general terms, which again I just find too vague. And when I listened to it, he had briefly discussed that he also agreed with Mr. Grossman about the minutes, and he said he understood that the task force was understaffed, especially with the budget deficit, but that there were things we could do and that we should keep the public involved and do better outreach so we can move our ideas forward. So general terms on the task force doesn't really exactly reflect that. So I was hoping that we could just have a couple of things added.
Okay. Is there any public comment on this item?
Thomas Picarello. I'm on. Thank you for the comments regarding the minutes. That's one of the problems when we go back 4 months to try to recall what we said at a hearing. So perhaps your discussions with the clerk informally were successful. In the event that they were not, then there will be further challenges to your minute keeping. Thank you.
Thank you. Are there any other comments? Seeing none, we have a motion. Member Nee.
Yes. In light of Member Johnson's comments, I would like to offer a substitute motion to continue these minutes until our next regular meeting.
Member Wolf?
So moved. It's fine.
Okay.
I agree.
Any comments? Any public comment on the new motion? Seeing none, could we have the roll call, please?
On the motion, Member Snyder?
Yes.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Washburn?
Aye.
Washburn, aye. Madam Chair, we have 5 ayes. Motion passes.
Mr. Clerk, could we have the next item on the agenda, please?
The next item is file number 11023, hearing on the status of the May 18, 2011 order of determination of William Clark versus the Arts Commission.
We have two other minutes.
Number 2 and number 3?
I believe the motion was to move all the minutes.
Was it?
Was that my understanding? That wasn't.
My understanding was just item 1 was all it was called.
Item number 2 is approval of the May 12, 2011 regular meeting minutes.
Move to approve.
Second.
Member Wolf?
Same comments as the previous timestamps for each of the item for the audio.
Members? I also think that we could have more information about what members of the public said here as well. One thing I do like is I think the motions are pretty clear and detailed, the way they're stated, but member comments and public comments are sparse in these minutes. Is there any public comment on this motion? Okay.
Well, I would move to continue these also.
Second.
Is there any comment on this new motion? Okay, seeing none. Mr. Rustin, would you call the roll, please?
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Washburn?
Aye.
Washburn, aye. Madam Chair, we have 5 ayes. The motion passes.
Mr. Rustin, could we have the next item on the agenda, please?
Item number 3 is approval of May 10, 2011 regular meeting minutes.
So moved.
Second.
Member Wolf?
Same call, timestamp.
They
For
are
each item.
timestamped.
They are time.
Oh, they are. Sorry. Didn't turn the page.
Member Johnson?
I have two things. One is on page 14 of our package, page 3 of the minutes, the first line. It says, Member Nee told Mr. Grossman that DCA 3 had offered to a detailed. I'm assuming you mean to prepare a detailed. And then the other one is on the first page of the minutes, on page 12 of our packet. In item 2, it says, after the motion, it says, second withdraws because minutes allegedly violate section 6716. I'd like to request that the allegedly be moved because I was the second of that motion and I didn't allege it, I believed it. So even though we don't necessarily all agree whether that's true or not, I would request that that be removed.
Any other members? Is there any public comment on the motion regarding these minutes? Seeing none?
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Washburn?
Aye.
Washburn, aye. Madam Chair, we have 5 ayes. The motion passes.
All right, can we have the next item on the agenda, please?
Item number 4 is hearing on the status of the May 18, 2011 order of determination of William Clark versus the Arts Commission.
Mr. Clark, you have
Hello, everyone.
5 minutes.
Just to remind everyone, this complaint was originally, I made a request to Mr. Luis Cancel and Mr. Lazar in regards to why Ms. Evelyn Russell's job classification was changed from a classification of 14, what was it now? Excuse me. Was changed from 1426 step 3 to, which is a senior clerk typist, to a classification 3541 museum curator. And when I received the information, I had asked when and why her classification was changed, and I got the documents and information as to when it was changed, but they refused to give me any explanation or reason why it was changed, and the full task force found that in violation of section 6724 subsection C, subsection 6, in that I'm entitled to know why her job classification was changed. Since that time, you're probably all aware, Mr. Luis Cancel has resigned from the Arts Commission, and they're choosing a new person now, so maybe things will change in the future. But I have not received any information in regards to this request. I still want to know why it was changed, because I don't believe that the museum curator is a proper classification for the job that Ms. Russell was doing at that time. And since she left, I still don't know whether she was fired or she quit, because they won't give me that information. The new person who came on has come on in a job classification of, I believe it's the 1426. It's not a museum curator. So I would still like to get the information from the Arts Commission why Ms. Russell's was changed in the first place, why she was given a pay increase and a different job classification, which, according to the qualifications, are not the requirements of what she needs to do for a job. This is not a museum curator's job, and it's a senior clerk typist. So I just want to inform you that I have received nothing, and I know there are probably a lot going on at the Art Commission this week with what's happened. So I just want to make you aware that I haven't received anything.
Okay, thank you. Is there anyone present to offer facts and evidence in support of the complainant in this matter? Okay, seeing none, is there anyone here from the Arts Commission to speak on behalf of the respondent? You have 5 minutes, sir.
Of course, I'm Julio Matos, representing the Arts Commission and Streets Artists Program Director Howard Lazar. as their representative. I was asked to convey the following information relating to the complaint 11023 in the decision and order of determination issued by the task force on May 18, 2011. In the complaint, William Clark denied that he received an answer to his question as to why the job of former Arts Commission employee Evelyn Russell was changed from Job Code 1426 to Job Code 3541, which occurred in 2005. While he acknowledged receiving copies of the records furnished relative to his request, he stated that none of the documents I received contain any explanation why her job code section was changed from 1426 to 3541. I also have not received any verbal explanation from the Arts Commission why Mrs. Russell's job code was changed from 1426 to 3541. I believe that Section 67.24(6) of the Sunshine Ordinance requires the Art Commission to provide me with the information why Mrs. Russell's job code was changed from 1426 to 3541. Relative to Mr. Clark's request, we informed the Sunshine Ordinance Task Force at its hearing of April 26 that the Arts Commission on February 21, 2011 responded to Mr. Clark by letter with 16 documents comprising of 34 pages. We explained to Mr. Clark in our letter that as required by Section 67.24(e), and to the extent that we had responsive documents in the files, we are providing you with the copies of documents containing information regarding background, training, education, job descriptions for Mrs. Russell. We also stated this to the task force. Furthermore, we stated that these were all the documents on file with the Commission relative to Mr. Clark's request. Other than the furnished documents, we stated again that the Arts Commission has no document containing a narrative, explanation, or summary of the specific reason or reasons for the upgrading of Mrs. Russell's job classification. We also stated to the task force that the city's obligation under the Sunshine Ordinance, like the Public Records Act, is to produce public records in its custody. San Francisco Admin Code Section 67.20b, there is no requirement that a department or officer construct a document to meet the specifications of the request. Accordingly, we ask that the complaint is dismissed. Nevertheless, the task force on May 18th issued a decision in order of determination that the Arts Commission violated Sunshine Ordinance 67.24(c)(6) by not disclosing the reason for any performance-based increase in compensation for a staff member, and 67.21(e) for not sending a knowledgeable representative to the meeting. The decision and order, furthermore, ordered the Arts Commission to release the records requested within 5 days of the issuance of this order and to appear before the Compliance and Amendments Committee on July 12, 2011. Ordinarily, we would take issue with the fact that the Arts Commission did not receive the Task Force May 18th decision and order until June 24th, which automatically placed the Commission in violation of the order to release the records requested within 5 days. More important is the task force disregard of the Arts Commission statements that the documents furnished to Mr. Clark were all the documents on file with the Commission relative to Mr. Clark's request, that the Commission has no document containing a narrative, explanation, or summary of the specific reason or reasons for the upgrading of Mrs. Russell's job classification, that the city's obligation under the Sunshine Ordinance, like the Public Records Act, is to produce public records in its custody, and that there is no requirement that a department of the officer construct a document to meet the specifications of the request. We hereby reiterate the above statements to you, the Compliance Committee. We are unable to comply with the order to release the records requested because the Commission has no such records in its custody, and there is no requirement for a department or an officer to construct a document to meet a request.
Thank you. Is there anyone else present to offer facts and evidence in support of the respondent? Okay, seeing none, the matters with the task force. Member Nee.
Mr. Matos, please. Is there the request from Mr. Clark, if I heard it correctly, and perhaps one or both of you will tell me if I'm incorrect, but it seems to the he had requested not just documents, not just records, but also oral information that would satisfy his information request. And what I'm wondering is if, according to what we just heard, the documents that he received did not satisfy his request, and he did not receive oral information that would satisfy his request. And so what I'm wondering is there a reason that the oral information could not be given?
I have no comment on that one. I just don't know.
You don't know?
No.
That raises another question. We received an email through our clerk a few days ago stating that Mr. Lazar had to leave our last regular task force meeting because of an asthma attack, which we're certainly very sorry to hear.
Yes.
Is he feeling better now?
He is feeling better.
Good. Glad to hear it. Is there a reason he could not be here right now today?
As of earlier today, I actually just walked into the office and found out that they had an emergency, and I have no clue what happened today.
When you say they had an emergency?
Mr. Lazar.
A personal emergency?
Yes.
Okay. Thank you.
Okay, no problem.
Members? Member Wolf.
Mr. Montos, you mentioned in your testimony that you received the order, the decision, the order of determination on what date?
June 24th.
The decision was issued May 18th.
Yes.
Oh, June. Oh, the order of determination was
No,
June 18th. So 6 days later?
Let me see.
June 18th was
May 18th. We didn't, pretty much what he says here is that he did not receive it until June 24th from the May 18th issue of a decision in order of determination.
So it's almost,
I
it's
think
more
that
than a month.
I'm not too sure if that was the meeting that we actually had here that was actually, pretty much it was the end of the night and it was removed.
So it's continued to the next one. So even if it was June 18th, that the order, is that correct?
May 18th.
Correct. Oh, hold on a second.
Sorry.
Just administratively, correct me. What is the correct date that this order was finalized and sent out?
Through the chair, Member Wolf, the date that the document was sent out would be the June 18th.
So
The
June
meeting date is May 18th.
The meeting date was May 18th.
Yes.
And the order was sent out a month later?
In this case, yes, through the chair.
Was the May 18th meeting continued to the following? No, that wouldn't have. No, that doesn't make sense. Hold on a second. June 18th is a Saturday. And was a very significant day for me. So I'm a little confused. This says June 18th. So when was it was it sent out on the 18th?
Member Wolf, to give you I'll have to go back and look at my records to give you an exact date.
Okay. Okay. Thank you, Mr. Montos. Madam Chair, I don't know how to dispose with this. I can't reconcile the dates.
So the issue in your mind is whether there was a timely response.
I don't, unless somebody has recollection of how this, and I don't have the meeting of the minutes of the regular task force meeting to determine what happened 3 months ago.
Member Johnson.
Well, I agree that there's some issues to be resolved about the amount of time that it takes for the orders of determination to go out. But I think that Mr. Clark, in his explanation, said that what they really wanted to know was why, I forget the woman's name, but why the person that they felt whose job was the typist clerk was made a museum curator. And for me, it's an issue of this, what Member Nee was discussing about oral information, because they're saying they don't have to create a document, but they could easily just state the reasoning behind why her job title is now museum curator, rather than just provide them with documents. So I feel like they didn't respond with the information based on the fact that it wasn't written down on a document in the way that it was asked for.
Do you have a motion for what to do next?
Well, this one is against the Arts Commission, so we can't really send it to the Ethics Commission. Is there a suggestion from another member about an appropriate agency?
Madam Chair. Well,
Member Nee.
well, we have a choice of three others: the District Attorney, the California Attorney General, and the Board of Supervisors. Those are our choices.
What about, through the chair, potentially to Member Wolf? Is this a issue we could have taken up with the supervisor of records to say whether that information is public, or does that have to be a document?
Member Wolf.
With the regards to supervisor of records, that actually we can send it off to them, and then the supervisor of records has enforcement power to compel the documents to be produced if the supervisor of records finds that it's a public document or public information.
Right.
Under Section 6721D, I think it is.
Member Nee.
I'm not sure what purpose that would serve, though. The supervisor of records is there to determine whether an existing document is disclosable. And what we've heard today is that there were documents given to the complainants. The complainants say that those documents are not responsive to their request. We have also heard the respondents say that other documents that were requested don't exist, and they can't be forced to produce documents, to construct documents that don't exist. And then the third part of what we heard is that the complainants also asked for oral information, and that was not provided. So I don't think that going to the supervisor of records here is really, I don't think it would do us any good.
I have something to say about this. Since the crux of the matter here is a desire for some oral information, someone's recollection about what transpired to create this job reclassification, the only thing I could think to do that might remedy this is to refer this to the EOT, because it is an important issue. How do we handle matters where the information definitely does not exist on paper, and yet it must exist in the institutional memory of the department? And it's an interesting issue. I think it could be one where there's some education around this. Other than that, I'm pretty tapped out on this one. Member Wolf.
The reason why this has come to us today is to find out whether there was any compliance or not. The question is whether they have complied. I don't want to re-adjudicate the entire case. The question is whether, first of all, is there precedent? Has there been other employees that have had shifted job classifications, and were there any documents or discussion about that during that time? That, in and of itself, may be privileged information because it's a personnel matter. That may not be available. It could be redacted. You can have just a white piece of paper with the entire thing all blacked out. But at least you get the document.
There are no documents.
Right. So sans any documents, then there had to be some discussion from someone. Maybe this department isn't the place to be asking the question. Maybe human resources is the place to ask the question. And maybe that's why there's no oral information or no information about it. Maybe the person was, the rug got pulled out from underneath the person and they were transferred to somewhere else, because of some outside reason that the Arts Commission is not privy to. I'm sorry?
The person wasn't transferred. She does the same job, but she got a higher
I thought
grade.
it was under museum.
Yeah, that's the point. She doesn't work at the museum. She still does the same job.
It was a reclassification. Member Johnson.
I'm going to make a motion to send this. I really want us to try to enforce the order as it was and not try to change it or let somebody get out of it. I'd like to see our orders of determination enforced as they're issued. So I'm going to make a motion to refer this to the district attorney and the Board of Supervisors, especially in light of the information that came out about the investigation of the head of the San Francisco Arts Commission.
Second.
Is there any public comment on the motion before us?
Robert Clark. I support the motion wholeheartedly. I did want to make a couple of points. That you have to understand that Mr. Lazar was involved in this whole back and forth determining to reclassify Ms. Russell's to a museum curator step 1, step 5. And in the papers that we presented to you folks, there was information with Mr. Lazar being right in the middle of it. So if anybody knows why it's happening, it would be Mr. Lazar. And that's why when you said this was against the Art Commission, it's really against Mr. Lazar. And that's why we asked Mr. Lazar for oral information, because he was in the middle of it. And he was the one going back to human resources. And they were telling him how to rewrite her resume so that it would look more like she qualified for this museum curator. And when we went over the papers, I noticed that she was reclassified as not as a curator 1, step 1, but as a curator 1, step 5, which is the higher step of a curator 1. And her job pay in the papers that we gave you, Mr. Lazar said that, well, we gave her this new classification, which was essentially the same pay scale as what her previous one was. But when we looked through the papers, we found that step 5 was like a 10% pay raise, and step 4, which he could have even requested a step 4, was still slightly above her previous pay raise. And this raised questions to us, because he was telling us that it was basically the same pay raise. And when we looked at the papers, we realized that step 5 was 10% higher, step 4 was even slightly higher, and he could have given her a step 3. Step 3 was slightly below her pay raise. So the main point I'm just trying to make is that I fully support the motion, and I thank you for making it, and that I think that there's something going on here that has to be investigated, and I feel that Mr. Lazar is the person that this order determination should be directed at and sent over to the district attorney in Mr. Lazar's name, because he's the one, he does know the answers. He was involved in it, and he is the person that should know the oral reasons as to why he decided that he was going to request that she become a step 5, curator 1, step 5. Thank you.
Thank you. Any other public comment?
Good afternoon, Task Force. I want to commend Member Johnson for introducing this motion. As with the new grand jury report on the whistleblower program that suggests that if the citizens and city employees were to see an effective whistleblower program, there might be more of an incentive for employees to step up to the plate instead of running away from the whole retaliation issue. Similarly, by city departments learning that violations of an OD shall result in a referral to the district attorney or the city attorney, you might start getting more compliance with the orders of determination. So I strongly urge you to pass Ms. Johnson's motion. Thank you.
Thank you. Is there any other public comment on this motion? See none. Mr. Clerk, could you call the roll, please?
I have.
Oh, Member Wolf.
Yeah, what's troubling me about this case is that, and it's unlike any of the other cases, is that this case is against a body, an agency, not against a particular person. And it's asking the task force to identify who that person is. And that's a little unfair to the task force. I think it's a little unfair to the complainant also. If you know who the person is that might have that information, then that's the person that needs to be named as the person that the complaint is against. Now, the complaint form says what department it's for, and that's purely so we can identify what the complaint is being focused on. But the custodian of record is the person who would be violating the Sunshine Ordinance, and that's who we need to focus on. So it makes it very hard for us here when an item comes before us and it's complainant versus an agency. There's no enforcement for an agency. An agency is not a person. So we really need to focus. And I understand that after all this has come out, that it is. Yeah, I understand that, but the case name is against the Arts Commission.
Well, I'm just suggesting that you can name those people that received the request. They're named right here.
Well, that's right, but the complaint should be made out to a person. That's when you file a court case, it's against people.
The point of the ordinance is that they don't have to have an attorney. So if they need some assistance directing their complaint, I'm not going to make some sort of rule where if we know that and we didn't help them and try to change the case name, I don't think that's right for the public.
I understand that, but in this case, with the complainants and their history, they know who the complainant is and who they're asking the information for. I don't think this is some place where we really need to help a complainant that really doesn't understand the process. So, for me, it makes it a little difficult, and we end up sitting here now, some 30 minutes later, because it's not clear as to who exactly this is supposed to go to. Is it supposed to go to Mr. Cancel, or is the focus on Mr. Lazar, who is the responsible party? And it's not. And the question is if we're going to try to do an investigation, then let's do the investigation and not make a determination until we get down.
The determination has already been made.
I understand that, but the determination is against who? It doesn't say.
The clerks are saying Mr. Lazar would be the most appropriate
But the
person.
task force is the one that made the determination, not the clerks. Clerks only presented their
Then
cases.
make one.
Then make one what? All we can do is comply with that there was a violation by whatever the task force had determined. And the task force determined that the agency violated So who do you send the agency to? That's what I'm saying.
Well, then I'll revise my motion and add Mr. Lazar's name to it.
Second will accept.
Okay.
Is there any public comment on the revised motion?
Seems to me if Mr. Lazar is the most knowledgeable person, he should have been here today. And if you recommend something to the task force, he should be there for that hearing. And the fact that a complainant doesn't quite get the guidance that he needs in order to understand how to draw his complaint should not be to his disadvantage. I think it's the responsibility of whoever is taking the complaint and make sure he asks the right questions in order to frame it correctly. But I don't think after all this time, when everybody knows what the issue is, someone does know why this woman was elevated to this status. And the only question is, who is it? And it sounds to me like it's Mr. Lazar. Get him to attend a hearing and ask him.
On the amended motion, while I understand Member Wolf's concern, my understanding of the proposed changes to the Sunshine Ordinance is that whole section, remind me, 6734 is getting rid of the dichotomy between willful failure and willful, whatever the other concept is, and that you're getting rid of department heads, elected officials, and senior managers, and you're making it any city employee or agency or board. And while I know those haven't been adopted yet, that's the direction you're moving in. That's the direction the ordinance is moving in. And that's the direction that the city family, quote unquote, needs to get a grip on. That they are, whether it's their body acting as a person, like the Supreme Court is letting corporations act like individuals, those bodies, those commissions, those advisory groups can be as guilty of violating the Sunshine Ordinance as an individual. So we need to get beyond this.
Member Nee.
Just very quickly, could we get the clerk to contact building maintenance to see what the...
Is one of you leaning on the handicap? Yeah, I think they moved. They were leaning on the handicap that.
Okay. I guess we're good then.
On the amendment, I'm in support of naming Mr. Lazar because Mr. Lazar is the director of the Street Artist Program. Evelyn Russell is his only employee. He was the one that, through Mr. Kinsell, my brother, as the complainant, can clarify this, but I believe in the original complaint we named Mr. Lazar and Mr. Kinsell. And in the process of the papers, as I stated, it showed that Mr. Lazar was the primary person involved in deciding to have Ms. Russell's classification changed to a curator. So I have no problem with naming Mr. Lazar as the primary person that this complaint is against. And that's, again, why we went to Mr. Lazar. As when we got the original papers and read them over and saw what he was involved with the Department of Human Resources, working as a liaison between the two of them, to me, the papers that we presented as evidence clearly show Mr. Lazar is the person who's refusing to answer these questions, and he's the one who knows these answers because he was the one asking for her classification be changed to curator, which would be one thing if it was an actual legitimate request for a job function that she was qualified for. But the absurdity of it being for a curator, a museum curator, and as the papers that we presented, you can read them. It's clear that they're trying to concoct some kind of a resume so that Mr. Lazar, at the end of reading it, can say, "Oh, this is a wonderful resume. You wonderfully compare exactly with what a curator is. Therefore, I can give you this job as a curator and give you more money." And Mr. Lazar is the person that knows the reasons why. And so I support your amendment. Name Mr. Lazar in your amendment, because he is the person that we're trying to get the information from.
Thank you.
Thomas Piccirillo. I do appreciate the comments by Task Force Member Wolf, but I think they should have been made at the time of the order of determination, which was last June. The task force should be sunshine friendly to people who are trying to get documents and people who are trying to speak in a public forum. The fact that the complainant didn't originally know who the appropriate person was, the Sunshine Ordinance does require the party who is being requested to provide documents to identify who is responsible for having that information. That wasn't provided to Mr. Clark. So you should not allow the commission to be non-accountable. Mr. Lazarus seems to be the appropriate person, and you should make that finding. Thank you.
Thank you. Is there anyone else to speak on this motion? Seeing none. Member Nee?
Yes. As a matter of procedure, I believe the motion should be restated. The motion, as reads, is to refer this to the district attorney and the Board of Supervisors. I believe properly, and I will present it as a substitute motion, and that is to refer this matter back to the full task force with a recommendation for referral to the district attorney and the Board of Supervisors, naming Howard Lazar as the responsible, as the respondent.
So is the second okay with that? Or that?
This is a substitute motion.
Substitute motion. Do I have a second?
Yeah, I second.
Members? Is there public comment on the substitute motion? Okay. Seeing none, Mr. Rustin, would you call the roll, please?
It's not a complaint. It's an order of determination. It's not the same as a complaint. It's not the same as a complaint.
Actually, he's right. I think we've gotten lost here. I've gotten lost.
Respondent and then complainant each get 3 minutes
Right.
to provide
Okay.
any concluding or rebutting remarks.
Right. All right. Point well taken. So first, the respondent, Mr. Matos. You have 3 minutes. Okay.
Thank you. I didn't mean to jump on everybody.
No, fine.
Real quick, I just want to make you aware that in my letter, my request, it was sent to Mr. Kinsell, Mr. Lazar, and I specifically said I would like a copy of any documents in the possession of the Arts Commission which state when and or why Ms. Russell's job code was changed from 1426 to 3541. And then I said, if there are no documents, then I would like to be informed verbally why her job code was changed from 1426 to 3541. That was in my request. And Mr. Kinsell is the head of the Art Commission. He's the head of the department. He's supposed to decide who is to give verbal information out. And Mr. Lazar is the director of the Street Artist Program. He's the keeper of the records for the Street Artist Program. So I directed my request to both of them because it involved documents and verbal information. And since in this particular case, Ms. Russell's salary is paid through street art certification fees, which I pay, it doesn't come from the general fund, that I'm entitled to be aware of when an employee's salary is raised, and specifically why it is raised, if it's going to be changed to a different classification, because these fees are being raised consistently, and we're not being provided with information explaining why this is occurring. And in this particular case, I made my request to Mr. Lazar, and I find it pretty, but outrageous that there isn't a document or that this person can have a salary increase and a complete different job classification. One, there isn't a document anywhere that explains why that's necessary in the Arts Commission, but I'll go along that there are none. And two, that the director of the Arts Commission or the head of the Arts Commission or the director of the Street Arts Program doesn't know why her job was changed. And so I'm asking you, I support the motion and I thank you for that, but I just want to make you aware that I'm entitled to be made aware of these financial things that go on there, because my fee is being increased and people are being knocked out of the street artist program because they can no longer afford the fees. And I'm trying to get the fees reduced, and one way of doing that is to make sure people don't have job qualifications that are higher, that give them higher salaries than what they're entitled to. So I just want to make you aware that this is a financial thing it's a little different than money being given through the general fund, because this every penny comes out of the pockets of street artists. Thank you.
Thank you. All right. Members? Okay. Mr. Rustin, would you call the roll, please?
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Wolf? Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Washburn?
Aye.
Washburn. Madam Chair, we have 5 ayes. The motion passes.
All right. We have to vacate this room and move next door, which is where we regularly meet anyway. So I'm calling a 10 to 15-minute break for us to move next door. I appreciate your patience. The regular meeting of the Compliance and Amendments Committee of the Sunshine Ordinance Task Force is back in session at 5:04. Now is the time for public comment on items not on the agenda. Is there anyone to make public comment at this time? Okay, seeing none. Mr. Clerk? Go ahead.
Since this sort of falls in your purview, about the access to public records, you might want to disregard the public record known as Mr. Rosenfield's speech about the whistleblower report. He told the press factually incorrect information, that they've had this CARB committee for 7 years. Hasn't happened. I have a transcript that I labored over transcribing the go-back meeting in which the CARB was formed within the past year. They haven't been doing it every 7 years. So don't believe everything you read in the press, because you can't believe every public record you're going to get either.
Thank you. Is there any other public comment? All right. Mr. Clerk, could you call the next item on the agenda, please?
Yes, Madam Chair. The next item is item number 5, hearing on the status of the April 26, 2011 order of determination of Patrick Mooney Shaw against the Controller's Office and the Ethics Commission.
Madam Chair?
Yes.
For reasons previously stated, I am recused from this item.
Do we have a motion for, we don't?
Not necessary. It's
Okay.
done.
Okay, oh, it's already done. All right, thank you. Okay, Mr. Minette-Shaw, you have 5 minutes.
Thank you, Member Washburn. I want to remind you, here we are 7 months after I first filed this public records request in January. On April 26, the full task force ruled in my favor on complaint 11013. And on June 14th, the SOTF belatedly issued an order of determination. Here we are, at least a month after the order of determination, and guess what? They were told, produce the records within 5 days, and I still don't have them. And that's because on June 24th, Mr. St. Croix flatly notified the task force that, quote, I'm reading his last sentence in his June 24th letter to you. For these reasons, the Ethics Commission will not release the records requested. He's in clear violation of the order of determination. For that matter, so is Ms. Letiju, who also said that the Controller's Office would not produce any documents in response to the order of determination on 11013 either. Mr. St. Croix whines about the processes that the SOTF used. And then he boldly put in the draft that was considered at the Ethics Commission last night on finding number 2 of the Sleeping Watchdog Ethics Commission report, grand jury report, that the task force routinely ignores the advice of its city attorney, which we now know is going to be struck from this draft. Routinely ignores the advice of the city attorney as well as due process considerations. Well, guess what? He doesn't get to pick and choose what your processes are. And there was no due process violation in whether you made a motion to word the OD in one particular manner or another. That is not a due process violation. Ms. Letiju's letter of July 11th, in which she has mysteriously learned to start dating documents above the addressee, says it is unclear whether this provision is intended to apply to someone in my position who is neither an elected official nor a department head. She apparently doesn't know how to read that first sentence of 67.34 that says elected officials, comma, department head, comma, or other managerial employee, which all that language is going to go away when you modify your the new language for the ordinance amendments. And that will apply to her, like it will apply to every city employee, as it should. So, given that, both agencies, ethics and the controllers, have failed to comply by the deadline in the orders of determination, that violation of not producing the records as they were ordered to must be considered willful, because they simply refuse to do it. So I would ask that somebody introduce the motion today to send this back to the full Sunshine Task Force and maybe take more vacation time, because I like doing that. With a strong recommendation from compliance that the full task force find both agencies in willful violation of the order of determination on 11013. Thank you.
Thank you. Is there anyone in attendance to offer facts and evidence in support of the complainant? Okay, seeing none, the respondent has 5 minutes. Do
Do we split the time, or does each of them have 5 minutes? Each of you has 5 minutes to speak.
Ladies and gentlemen, John St. Croix, representing the Ethics Commission. The bottom line here for us is that we have had this disagreement with the task force for a period of time, and the Ethics Commission firmly believes that the official information privilege allows withholding of these documents, and we believe that the Charter compels withholding of these documents. We've made that clear in our correspondences to you. Those essential reasons are bedrock to our point of view on this process, is notwithstanding. As such, with all due respect, we cannot comply with the order of determination to disclose these documents because we believe the law prohibits their disclosure. That's really all I have to say. We're at odds on this. I'm respectful of the fact that may be frustrating to you, but you've made a legal determination. We have made an opposing legal determination, and we're standing by ours.
Thank you.
Tanya Ledishu, Controller's Office. And we also have responded on 2 occasions regarding this request, and we too have carefully considered your request. We've looked at our laws and the administrative code as well as state laws that govern the program, and we remain consistent with the fact that we will not release those records. And I have nothing further to add.
Thank you. Is there anyone here to offer facts and evidence in support of the respondent? Seeing none, the matter is with the task force for discussion and questions. Not yet. We want a chance to ask questions of you. Members? Member Wolf.
Yeah, Mr. St. Croix. And it'd be good if you sat in the front. It'd be easier instead of walking the hallway. In your letter, June 28th, on the 3rd paragraph, you say no motion was made or voted on by the task force during the April 26th hearing that ordered the Ethics Commission to release the records or that ordered the Commission to appear before the Compliance and Amendments Committee, but it's in the order. And I was at that meeting, and that's how the motion went. So I'm a little confused as why you believe that, or the Ethics Commission believes that that's the case. I mean, I'd be happy. We can, I'm sure, corroborate it with the recording, but I'm pretty sure the order actually says it in and of itself. So can you explain why that?
Well, according to the review of my staff, even if notwithstanding that the order says it, it wasn't part of the motion made at the hearing. And again, that itself is probably, Mr. Wolf, a fixable problem, which is why I didn't address it in my earlier comments. There's an underlying unfixable problem from my point of view.
Okay, because usually when it's kind of a little pro forma for us when after making a determination that because the ordinance automatically states that within 5 days that it would the items would be produced, that it automatically gets included into the determination. It's pro forma. It does lots of times doesn't even need to be said. It's just part of the procedure. But I remember on this particular day that it was. I mean, I'll go back and I'll listen. I just was a little confused after reading it and then reading the document. But that's okay. That's here nor there. With the matter itself, the concern about this is that we've heard from both Dr. Kerr and Maria Rivero on this issue, and that they are the actual whistleblowers, and that they have requested that the documents be opened. And so it seems a little odd to me because in the controller's letter, it says we've cited the laws that we have relied on in good faith to withhold the records requested by the complainant. But the complainant is the one requesting the records that they have. Well, actually, it's Mr. Manette Shaw who's the complainant, so so that's incorrect. But the actual whistleblowers actually have asked that the items be revealed. Is it your stance that even if the whistleblowers themselves have asked or requested the items be revealed, that they would not be, the city would not reveal the information?
Yes, sir. When we conduct investigations, even original complainants to those aren't privy to all of the files in an investigatory file. Nor is the respondent. There are times when complainants and respondents release information that they have on their own outside of my control. But our reading of the law is the documents that we have custody of, we have to maintain the confidentiality of.
And has this issue been resolved yet?
This particular...
Okay, this particular whistleblower case. Has it been resolved? Is it over?
I don't know. I'm not supposed to confirm, deny, or discuss cases. I think that I will go out on a limb and tell you the case is pending.
Okay, so it's in process. Okay, that's... Anything else to ask? Thank you.
If I may, I mean, I know sometimes people behind me can tell you that of their own free will, and I'm not supposed to do it. I know it seems a little silly, but...
Well, I understand what the city's process and its liabilities are with regards to these things. The concern that we have is that the FPPC and other agencies up and down the state reveal lots of information.
Gary Brown made them stop.
Oh, you made them stop. Okay.
Member Johnson.
Go for it.
No, he made them stop. Keep that in mind. It's not just the Republicans. Because it happened on May 24th. He made them remove all information from the website. It's a policy. It's a policy decision. And I want to say I really appreciate all of the parties coming. I really appreciate your being here. And I really appreciate that you really narrowed it down to exactly what it is. I agree with you. It's an unresolvable, it's not unresolvable, but it is a real divot that we're in right now because it's kind of the people versus the agencies that have a circular oversight. We have no agency to send this to. Our own governor doesn't even allow ethics investigations. But I would like to point out to the members of the public who are here, that same protection doesn't apply to you. And I would like to point out the gentleman who was, I can't think of his name right now, but when he was accused of the Atlantic City bombing, and it turned out it wasn't him, nobody protected his identity when there was an investigation. And the same thing with the gentleman, or whatever you want to call him, he has a history, the guy that was arrested, not because he is, there's evidence that he has anything to do with beating Brian Stowe, but that is what is being reported. He's being held on completely different charges. So that it doesn't, I don't understand why the city employees and the politicians feel like they have a protection that the rest of the public doesn't have. I'm just pointing it out. So I think our real question here as the committee is to decide who can we send this question to, because the real and I pointed this out when I was having the discussion with the controller's office during this meeting, that the only oversight they have are themselves. There's no, if you send it to the Ethics Commission, they've already told you what they think. Right, if you send it to the Attorney General, who is Kamala Harris, we already know what she thinks. If you send it to the District Attorney's Office or the City Attorney's Office, that's what they think. Now, I believe that the FPPC thing that you pointed out shows that it's a matter of policy, depending on who is having the say they put up the investigations or they take them down. I'm surprised that Jerry Brown would have it taken down. But we need to figure out who we could send this to if we really want to keep our orders of determination enforced, because we have to have some sort of oversight of somebody that's not involved in the circle. Because the only oversight there is the government audit and oversight, which is the Board of Supervisors, which means... Well, the Government Audit and Oversight Committee of the Board of Supervisors is who she reports to, but that happens to be Supervisor Campos. And while I like Supervisor Campos, the problem with it is that he won't always be the supervisor, but if somebody were to turn him in, it would go into the loop. And we didn't ask for the documents necessarily that were related to the investigation. And I remember in this particular case, it was that we should have the right to know which agency the black hole goes into. So we wanted to be able to see the documents that didn't have anything related to the actual investigation, but where the two, where the agencies were sending it. So if we want to make an order, if we want to make sure our orders of determination are enforced, we need to follow the course, that if this is what we decided and this is what we mean, we're going to have to find a place to send it.
Okay. Member Wolf, and then I have something.
Yeah, the crux of this particular case is not necessarily the actual information of the details of the whistleblower case. What this is, and if I remember correctly and have read everything I could to refresh my memory on this, is for correspondence about this between two agencies and the time frame between which those agencies had discussions and the time that it was determined that it would be then classified as a whistleblower case. And so then becomes the question of, are there any documents prior to it being classified as a whistleblower case between the two agencies that the complainant has requested? So I'm going to go down that road for a few minutes.
I strongly urge you not to do that.
Why not?
Because they're telling you that it doesn't matter which documents
But
they are.
You know
that
what?
They're refusing to turn over any documents.
I would appreciate if I can go down the road.
Yeah, but you're re-adjudicating exactly what we
Member
did before.
Johnson, let's hear what Member Wolf has to say.
I feel that we're here to determine whether there was compliance or not. Okay, and the compliance is whether that information was handed over to the complainant or not. My questions are going to be, where's that information? Well, but why presuppose it if I don't get I feel like you're censoring me.
I'm not trying to censor you, but Mr. St. Croix literally stood in front of you and said nothing will be available to you, nothing. And so did the controller. So it doesn't matter how you ask for them.
Through the chair, I am not going to be asking about any information regarding from the point it was classified as a whistleblower case. I'm going to be asking questions prior to it being classified as a whistleblower case, because that is what the complainant is asking for. The complainant doesn't know when.
Member Johnson, could you allow Member Wolf to continue, please?
Okay, so we'll start with Ms. Ledigiu. So let me ask a question first, okay? So because I don't want to waste a whole lot of time on this, if it's going to end up in another dead end. The question I have is did this information that came to you prior to you or anybody else classifying it as a whistleblower case, did you provide? Did it come to you first, or did it come to you already stamped as a whistleblower case?
At the point of any documentation coming to the whistleblower program, it is considered a whistleblower complaint.
So you're the beginning of the whistleblower complaint process?
Beginning.
Okay. Mr. St. Croix. Did the information that was brought to you by Dr. Kerr and Dr. Rivero, was it brought to you initially? Or was it after it was already stamped as a whistleblower case?
To my knowledge, they went to the whistleblower hotline first before they came directly to the Ethics Commission.
Okay, thank you. Mr. Manette-Shaw, what information do you have that there was any communications prior to it going to the whistleblower hotline?
Okay, so I in answering that question, I need to clarify with you that on this case, you are right. I asked for correspondence. The next case, the next agenda item, I asked for the investigative packet and the closing memo.
Let's
wait.
about this.
I don't want you forgetting that when we get to that case. But to answer your question, Proposition C in the voter guide that was incorporated at section F1 something or other. I can look up the citation if you need. Says that the Controller's Office is supposed to conduct an investigation. It does not say that they can triage it to another city department. They are supposed to investigate a complaint unless there is a written communication from ethics that says, drop the case, hold on, we're investigating. Well, guess what? The charter or the administrative code, section F1.117 or 1111 or 107, whatever it is, doesn't permit that, okay? They are supposed to investigate it, but unless there is a written communication. So I said to myself, okay, they haven't done anything, so I want that drop the case letter. It must exist. But it's not even whether they get to choose the demarcation point at which it becomes confidential. Because when it was submitted by Drs. Kerr and Rivero, they did not request confidentiality. And it was only much later that ethics and the city controller put that confidentiality stamp on it. And I also have the citation, unfortunately not with me, that this whole balancing test thing hinges on the point at which the confidentiality was raised, okay? There has been no confidentiality raised by the two whistleblowers. They can't claim that. And in fact, Mr. St. Croix just told you in his attempts to continue adjudicating what the task force discussed on April 26th when it ruled in my favor, that they are still asserting the quote-unquote official information privilege. Guess what? Sunshine Task Force, the Sunshine Ordinance clearly says they cannot make that assertion. They cannot invoke official information. It's right there in the Sunshine Ordinance. They cannot invoke 6254. That's also in the ordinance. And amazingly, yesterday, in this draft discussed at ethics on finding number 3, the Ethics Commission is claiming to respond to the grand jury. Additionally, since staff resources are limited, it does not make sense to duplicate the work of other law enforcement agencies, with the key word being other law enforcement agencies. Mr. St. Croix thinks he is a law enforcement agency. He's not. He's an ethics commission. Law enforcement is police. Law enforcement is sheriff. Law enforcement is CHP. Law enforcement is not Mr. St. Croix. So for him to keep coming back here and saying that they can use the official information privilege, he can't. It's not allowed in the ordinance. He's not a law enforcement agency. Confidentiality had not been requested by the two whistleblowers in question at the time they submitted their complaint, and they have subsequently submitted several statements to both controller and ethics that they do not want their case held as confidential. So they can't keep hiding behind confidentiality as a means to invoke secrecy. Did I answer your question?
Less.
Thank you.
Members, are there other questions, comments, discussion? Okay. At this time, first the respondent and then the complainant have 3 minutes each to rebut.
I just want to state that confidentiality is not an option. It is part of the process, and it's part of the laws that we abide by, and it's not an option of any whistleblower or complainant.
Thank you.
The grand jury says it's supposed to be an option. The grand jury says in the whistleblower grand jury report that the confidentiality button in cows isn't there. Well, it is there. It just doesn't work. If you look at the screen printouts, it's got confidential right up there. A little radio button or a checkbox box. I think several of the documents on the city controller's whistleblower webpage discusses whether complainants who are filing whistleblower complaints can in fact request confidentiality. So if it's not optional and it's part of the package, why do they have it built into cows? Why do they have a Microsoft Access database designer put the damn button up there unless they intended to use it for something? Why in their program materials did they put that in there to permit it if it's not permittable? So I come back to, you guys appear right now to be re-adjudicating what the full task force already determined on April 26th. Seems like you were hashing this out all over again, when instead what you should be doing is simply focusing on what did the OD say, did they do anything, did I get what you guys ordered them to give me, and I'm not hearing that discussion. And that's what you're supposed to be doing here. And because they didn't respond to the OD, as I testified on the earlier agenda item, the more you send these ODs back to the full task force with a recommendation of willful failure to comply with the OD, the sooner you're going to start getting compliance to the ODs. That if they get it, that somehow you have somebody to send it to for enforcement, whether it's the Board of Soups or a district attorney who chooses not to act on your further referral, or the city attorney refuses to act on your referral to them. You don't have an option, I don't think, with all due respect, Ms. Johnson, to decide and to sit here and say, well, gee, we really don't have a further place to send it to, so we're not going to send it anywhere. Procedurally, if I were an administrative law judge, I would want to hear, so Patrick, when they went to enforce your OD, what did the compliance committee do? Oh, gee, admin judge, they threw their hands up saying they didn't have anything, anywhere to send it to, so we didn't send it anywhere. If you send it to the task force and they refer it to the DA, and the DA does nothing, then if I go to the Superior Court for enforcement, at least the processes will have been followed.
Thank you. The matter's back with the task force for a motion. Member Johnson.
I would just like to correct the record that I did not say we should not send it somewhere. I was trying to say that we need to really assess the best place to send it, because we frequently send willful violations to the Ethics Commission, but it is a circular oversight. So it isn't that I would let it fall through the cracks.
Okay, I stand
But I just want to point that out. I don't want to argue about it. I'm just saying that I don't want on the record that that was what I had said. I'm just trying to.
Okay,
find
I'm sorry I misspoke.
the best
I do
place.
want to emphasize, though, that this needs to go back to the full task force with a finding of willful failure.
I mean, I understand that. It's the reason why I didn't want to go. I didn't want to censor Member Wolf. It muddies the waters a lot when we go back and re-adjudicate and re-go through the issues instead of focusing on whether. I mean, it's clear we have a disagreement with the controller and the ethics commission.
Mm-hmm.
So we either want to, enforce our orders of determination or not.
Do you have a motion?
Or on the best agency to send it to. I would like to hear your thoughts.
Member Snyder? Member Wolf?
There's only two agencies you can send it to. That's the district attorney or the attorney general.
Do you
That's
have
the
a
only-
preference or both, or
But I'm sorry?
do you have a preference or both?
I don't have a preference. You can do both. The problem with willful failure when you read 6734 is that it's specifically supposed to go to the ethics commission.
What do you do if it is the ethics commission?
Then I don't know. Then, well, right. There could be a case with regards to the city attorney's case where they had to send that case over to the Oakland city attorney to adjudicate it. But the question, it's something that we've never done before. We can suggest it. All we're doing is making a recommendation to the task force. Task force is going to have to have it out anyway. I would at least move in that direction.
So you're moving that we send this matter back to the task force for determination of the best other body to send this to?
Considering that there's a conflict.
Giving us all some more time to think about it.
But I would suggest that we would at least forward it with some kind of a recommendation so that they can then discuss it, as opposed to leaving it open-ended. For example, I would at least refer it to the district attorney or the attorney general's office, and I would also send a copy of the referral to the San Francisco civil grand jury.
Is that your motion?
Is that your motion?
Yeah, make a motion to refer it to recommend that to the full task force.
I'll second it for the purposes of getting it back to the task force so there could
Could
be
you
more
restate
discussion on
it
it.
for the members of the public?
We're going to make a recommendation to the motion. I've moved that we make a recommendation to the full task force to refer. I'm referring it for willful violation for failure to comply with the order of determination to the district attorney and the attorney general's office with a copy to the San Francisco civil grand jury, and with the potential that because of the conflict, it could be the Oakland. It could potentially be the Oakland Ethics Commission.
Okay. I'd like to hear from the members of the public on this motion. Is there public comment on this motion?
My name is Derek Kerr. I appreciate your deliberations and your time, and also Mr. Monette Shaw's efforts on behalf of open government and our whistleblower situation. All of this is important because retaliation does occur. That's just a reality. And also, the investigations of whistleblower complaints are inefficient and prolonged, and they go all over the place. Many staff members see them. They go to the whistleblower program, they go to ethics, then they go to the DA, then they go to the city attorney. The city attorney defends the very people whom we are reporting, especially with high-risk complaints like ours, where we named high-level city officials for amounts exceeding $50,000 in liabilities for the city. A lot of people look into this. So it's not all that confidential. And when they investigate, they have to talk to the people that we report. So the respondents know what we've experienced is not confidentiality, it's secrecy. Things are being hidden. Whether the investigation is open or closed, it's all confidential. It doesn't matter. I'll just share with you that when I brought my retaliation complaint to the Ethics Commission, basically I was told to get a lawyer. I did that. My attorneys are demanding to depose the Ethics Commission and the Controller's Whistleblower Program to find out how they manage whistleblower complaints in general and how they handled our whistleblower complaint in particular. It's quite possible that the way the investigation is handled actually is not confidential, and things get out and retaliation occurs. Thank you.
Thank you. Is there additional public comment?
Hi, Commissioners. I'm Dr. Maria Rivero. I'm the other whistleblower who's party to this case, and I just want to say in the strongest possible terms that I support the motion that you guys are deliberating about. We're asking for a memo, a ministerial memo between two parties, not any confidential kind of information in this matter. And we need this because we both lost our jobs after 20 and 22 years. So thank you for being in support of open government.
Thomas Piccirillo. A couple of points. First, you are the compliance committee. There's already been an adjudication by the full task force that there was a violation of the Sunshine Ordinance. You should not have the ability or the jurisdiction to relitigate the issues that have already been vetted by the full task force. I think it's your responsibility only to ascertain whether or not there's been compliance or not. Secondly, I don't understand why Mr. Shaw was requesting these documents and not the whistleblowers themselves. If the whistleblowers are represented by attorneys, they certainly can issue subpoena duces tecums and let a judge decide this issue that, quite frankly, none of you have the ability to resolve.
Excuse me.
Finally, let me say this. Putting aside the grand jury report on the Ethics Commission and putting aside the grand jury report on the whistleblower program in the city, you should enforce the Sunshine Ordinance, but this is not the venue to relitigate issues that have already been adjudicated by the full task force. So I urge you to either make a finding that there's been compliance or non-compliance. The recommendations, obviously, should go outside the city and the county of San Francisco. Perhaps the Attorney General, The grand jury, I don't know if they have jurisdiction on this type of matter, but certainly the Attorney General does. So you should refer this matter back to the full task force with a finding of serious and willful, and letting the Attorney General determine the outcome. Thank you.
Thank you.
Well, I think it's pretty clear, because it's been stated, that your job is limited to monitoring whether there's compliance, and I think it's pretty clear there hasn't been, and there's just no room in the process that's been assigned to you to review what happened at the original hearing. So any discussion about, you know, whether they were a law enforcement agency or whether the Sunshine Ordinance provision on 6255 or whatever applies is irrelevant here. But what is relevant here is your recommendation, and that's what I want to focus on. I think it should be clearly understood that the Ethics Commission speaks through Mr. St. Croix. He is the department head. He executes the actions of the Ethics Commission. They make the policy, they make the decision, but he is the actor, and he clearly falls within 6734, which reads, willful failure of any elected official, department head, which is what he is, to discharge any duties imposed by the Sunshine Ordinance, the Brown Act, or the Public Records Act shall be deemed official misconduct. And what's important here is that once you make that finding, it's in stone. It's in stone. The Ethics Commission cannot, through Mr. St. Croix's the regulations under which he operates, get it dismissed. It has to be heard by the Ethics Commission, and if it's disqualified because he is their department head, it has to go somewhere else, maybe Oakland, maybe somewhere else. But it cannot be dismissed arbitrarily by anybody at the Ethics Commission or on its staff. And that's what I suggest you do, because what Mr. St. Croix and actually the representative of the Controller's Office are doing is exactly the same thing. They're poking their finger in your eyes, and they're saying, we don't care what you tell us to do. We're going to do what we want to do, even though, and believe me, the legal support for what they're doing is shaky at best. And keep in mind, the Ethics Commission has agreed, has obligated itself under its own bylaws to comply with the Sunshine Ordinance. And that includes the Supremacy Clause. It includes the provisions that disallow the application of 1040, the provision that they're relying on, and such. So my recommendation is that your recommendation include a finding of official misconduct on both. Thank you.
Thank you. Members?
Yeah, you know, Guy is making a pretty good statement, and I agree with that. I think my contention is I wouldn't be trying to send this to Oakland. I would have another agenda item to figure out the continued steps of escalation. I mean, it feels like if you go to Oakland, you're going sideways instead of upward, and somewhere you have to keep going upward until you get to some type of legal lawsuit action or something. I just think that the system isn't working. You know, with my case, with other cases, these people come here or they don't come here, and you know, you never get the documents that you requested. And to the people behind me, it's just very tragic because whistleblowers don't have any type of protection. From the 9/11 to Katrina to their issues to just almost everything. The whistleblowers have no type of protection, and they're like, they stand up and do what's right, and then they get attacked and abused.
Thank you. Is there any other public comment on the motion? Members? Member Johnson.
I think potentially in light of Mr. Grossman's recommendation that perhaps a good course of action is to recommend we send it for official misconduct to the Ethics Commission and to the district attorney to start sort of the ladder of paper trail of how it goes. And then if it gets, we can always call in the Oakland Ethics Commission, like he said. So I'd like to amend my motion.
Okay, it's the second.
But to also include the civil grand jury. I still want to send a copy of the referral to the civil grand jury. They're investigating, they're making comments on both of these things.
Okay, so could you state the full motion for everyone, please?
To move for willful failure, official misconduct, to recommend to the full task force to send it to the district attorney and the Ethics Commission with a copy to the San Francisco civil grand jury.
Second.
Okay. Is there any public? Oh, Member Wolf seconded.
It's okay.
This is amended.
Yeah.
Amended. Okay. All right.
Adding to her own.
Well, I've taken out the attorney general.
Okay. Well, this is our recommendation. Okay. Is there any public comment on the amended motion?
Well, I think you're going to have to identify the people, though, who committed the serious and willful, because then you're going to say that there's been serious and willful misconduct without naming an individual. It's not going to get you anywhere. So your motion needs to specify which person or persons has committed the serious and willful.
Was Member Johnson?
I'm wondering what the task force members think about naming the names now or recommending or letting the task force do it. In order for it to be willful misconduct, it has to be against person anyway.
Right.
So for Mr. St. Croix and Ms. Ledigiu.
Maker or the second? I think could go either way. We could specify names now or wait until the full task force. Member Johnson?
I realize we'll just do it now.
Okay. All right.
So that means we amended it one more time.
Is it okay with the second?
It's fine. Yes.
All right. Is there any public comment on the amended motion? Okay, seeing none, Mr. Clerk, would you call the roll, please?
Yes, Madam Chair. Member Snyder?
Aye.
Snyder, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Washburn?
Aye.
Washburn, aye. Madam Chair, we have 4 ayes. The motion passes.
Mr. Clerk, could you call the next item on the agenda, please?
The next item is hearing on the status of the May 18, 2011 order of determination of Patrick Monet-Shaw against the Ethics Commission.
Pardon me?
Madam Chair, should I recall Member Nee?
Oh, okay. Oh, I'm not sure if he. Oh, it was only for one.
Yeah.
Okay, all right. Oh, okay, all right.
You have to get what?
Our recused member, we're letting them know it's the other case.
All right. Mr. Manette Shaw, you have 5 minutes.
Thank you so much. I want to thank the Compliance Committee from the bottom of my heart for that motion. As painful as it was to go through a few amendments, it's perfectly worded. Thank you. I had hoped Member Nee would have been recused, but at the back of the room so we could have heard the entire conversation, because I'm going to appeal to you to let's keep this next one within the 15 minutes that's on the agenda. Largely, it covers many of the same issues where Mr. St. Croix and Ms. Lettigiou are going to come up here and say that they respectfully disagree with you, and that the bottom line is the Ethics Commission and the SOTF have this angst going on, which I get jurisdictionally between the two bodies. I want to remind this Compliance Committee again that this case is a little bit different, that I'm not asking just for correspondence. I want to see the investigative file and the closing memo, because I really, 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 really don't believe Mr. St. Croix when he violates the Ethics Commission's own rules and admits to you that the Dr. Kerr, Dr. Rivero third whistleblower complaint about the robbed money from the Laguna Honda Patient Gift Fund is still pending. Does anyone believe that? If it was still pending, would Ms. Lettigiou and the city services auditor have concluded auditing that fund? If it's still under investigation, how could a CSA audit be finished? Conversely, if the CSA audit is done, what can ethics still be investigating on their own? So they may get back up here again and play that violin of official information privilege and 1040 and 6256, 6574, the alphabet soup of CIPRA provisions and other citations that simply don't apply in this case. They have no legs to stand on. So let's keep this within the 15 minutes. Let's not try to have this Compliance Committee re-adjudicate what the full task force ruled, in this case on May 18th, when the task force ruled in favor of me on 11014. On June 7th, the order of determination was written. It was written quite excellently by then Chair Nee, who did an absolutely superb job of writing that order of determination. Summarized the whole case in, what, a 3-4 page OD that made perfect sense. I was supposed to get access to those records within 5 days. Well, here we are, at least a month later. I still don't have them. And he's saying that the Ethics Commission, who, by the way, has not held an open hearing on my complaints, Mr. St. Croix has unilaterally decided what the Ethics Commission's response is going to be. And that response is, I'm not going to get the records. So, again, I want to be really clear. I would like a motion from this Compliance Committee referring the matter back to the full task force, willful failure under 67.34. He's the department head, she's the senior manager. 6734 should be jurisdiction for the full task force to once again rule that there's been willful failure, which constitutes official misconduct. So can we make this a 15-minute affair? Thank you.
The respondent now has 5 minutes.
Facts and evidence. Facts and
Oh, I'm
evidence.
sorry. Is there anyone here to offer facts and evidence in support of the complainant? Seeing none, the respondent has 5 minutes.
Ladies and gentlemen, my response is identical to the one that I offered to you on the last item. For Mr. Nee's benefit, I'll simply iterate that we believe that the official information privilege allows the confidentiality of these documents, and we believe the charter language compels the confidentiality of these documents, and therefore I do what I have to do under the law, not because I want to, because I have to. I would add something that I didn't say before, that the adversarial relationship that I have, that the Ethics Commission has with this body, does not give me any pleasure. My life would be a lot easier if people asked for these documents and I gave them to them. I'm not doing this because it makes me feel good or happy. I've been vilified by a lot of people at a lot of meetings. I understand that goes with the territory because I am making these decisions. I am interpreting the direction of the Ethics Commission. I am responsible, and I'm taking responsibility for these. But it's not an easy job. And one of the things that Ms. Johnson said earlier about some rules protecting city employees versus rules protecting the public, to me is true, but only partially true. City employees that are keeping these records confidential are also protecting members of the public. We have names of witnesses in these lists. We have staff strategies and staff records of interviews that if respondents were to see would aid them in their cases. I would tell you, for example, in some cases where we interview people that know the respondent and it gets back to respondent, those witnesses frequently change their stories. So that puts us at a disadvantage. There is a germ of reason that the law allows confidentiality in some places, and that's the position that we're coming from. I understand we fundamentally disagree on those degrees, and I respect that your position is substantially different than ours, but again, I have to maintain what we think is the right thing to do under the law. Thank you.
Is there anyone here to offer facts and evidence in support of the respondent? Okay, seeing none, the matters with the task force for comments and discussion and questions. Member Nee.
Just a very brief comment. In acknowledging the adversariality that is developed between the Ethics Commission and this task force, I think Mr. St. Croix did it in a very gracious fashion.
Members? We are keeping this brief per request of the complainant. The respondent now has 3 minutes for a rebuttal. Okay. The complainant?
I get it that there's a germ of reason. I get it that he may have been eloquent about the adversarial relationship between two reasonable citizens' bodies. But you can't let the complainant get stuck in between the adversarial relationship or the germ of reason. What has troubled me about their absolute claim of total confidentiality is this. Well, the whistleblowers, if they elect the confidentiality at the outset, are entitled to it. I am not fully convinced that other city employees should get the equal confidentiality protection that Ms. Lettigiou has all along asserted is of utmost concern to the whistleblower program. If they have nothing to fear, nothing to hide, they shouldn't need a veil of confidentiality of their own. There goes the germ of reason about why anybody other than the whistleblower themselves deserve confidentiality. I'm not convinced that any witnesses, anyone that they go interviewing as they're investigating their little investigation of a dog, if you'll allow my literary allusion, should be given confidentiality to the point that members of the public can't access those documents. To answer the previous speaker's point, why do I want that document from the previous case, 113? Because it's a public record. And if it's not, it should be. If one agency tells another one to suspend their investigation, it should be for good cause. And members of the public should be able to see it. And one of the reasons I'm asking for the investigative file is because I bet you that drop the case letter or drop the case phone call in a phone log, or that drop the case seriatim meeting during a lunch somewhere occurred. And we should be able to see, as private citizens, what's in that file without them being able to claim that confidentiality of some little secretary sitting, over there in some other department is totally protected. And I, as a private citizen, have no protections about being able to access public records.
Thank you. Okay, the matter's back with the task force for a motion. Member Johnson?
I want to make sure that I understand our order of determination includes their ability to redact some confidential information. Okay, correct? Or whatever is redactable under the CPRA.
Actually, we do on page 27 of the packet, page 2 of the order of determination. The very last line says that ethics must release the information with any appropriate redactions. So we made allowance for that.
I would move.
Member Snyder.
Yeah, sorry. I would move to find a willful violation and refer to the Ethics Commission and also the DA and copy as well. Member Johnson, you had a copy sent in the previous agenda item. You had a copy sent to,
The civil grand jury.
Right.
San Francisco civil grand jury.
To the civil grand jury. Didn't I say that?
Yeah, 6734.
Willful failure, yeah. But you said to the Ethics Commission, you didn't mean that.
Yes.
To the Ethics Commission.
Right. To the Ethics Commission and to the DA.
I second and offer to actually name Mr. St. Croix. Because it's against the Ethics Commission. So we have to name somebody for willful failure.
I did name Mr. St. Croix as responsible.
Yeah, but he's going to name it in the motion.
Yeah, I would accept that amendment.
Member Nee?
Friendly amendment again. I believe it would be proper to refer this back to the full task force with a recommendation
mistake.
for those
Yeah.
referrals.
Sorry, I was incomplete. That's indeed, I meant to say that.
Okay, for purposes of the public, could you restate the
So
motion?
I moved to find a willful violation, official misconduct, and refer back to back to the full task force, with a recommendation that it be forwarded on to the Ethics Commission, the DA, and with a copy sent to the civil grand jury, and that the violation specifically name Mr. St. Croix in his capacity as the director of the Ethics Commission.
Okay. At this time, we'd like to hear from members of the public on this motion.
Once again, thank you for your deliberations. This all began because of the inordinate delays in getting a response to our whistleblower complaint about the gift fund. All we wanted was an audit, and we couldn't get the audit. We had to go lobbying out in the community, get neighborhood groups involved, sending memos to supervisors. It was just a tremendous amount of work. And all the meantime, we're facing hostilities at work. So Mr. Monette-Shaw, and in his requests to you, is really asking, why were there all these delays? Can we get documents to explain the delays in these investigations? What we experienced felt like obstructionism. And it may be that they didn't have enough staff, or they were so busy with other things, but it felt like resistance. Similarly, the position that Mr. St. Croix and Ms. Ledigiu are taking now, although idealistic, feel like obstructionism. There's ways that this could be compromised. Letting us have redacted documents, letting us see things in camera, just looking at them in Mr. St. Croix's office and not getting a copy, or talking to us. But you know, we filed 3 whistleblower complaints, all high-risk, high-level officials in the last 2 years. We've never met with Mr. St. Croix or Ms. Ledigiu, and we've asked, please talk to us. What's going on? So there's no contact, there's no reaching, there's this wall of secrecy, of it's our business, it's not your business, and really, ultimately, this is everybody's business. And everybody has to have the ability to have a look at how they're running the business. We don't want to know what they're doing with the investigation, just why they stop it, how they triage, how did they decide to look at this one, not that one. Thank you.
Thank you. Is there other public comment on this motion?
Thomas Piccirillo for the audio. I feel saddened that Mr. St. Croix feels vilified. I would only say that I don't, the grand jury that did their report on the Ethics Commission, I don't believe had an agenda before they did their investigation. As to the motion, again, I would urge you to specify the person or persons who you are recommending for serious and willful. Thank you.
Is there additional public comment on this motion?
I don't think I touched Mr. St. Croix's comments with a 20-foot pole. I think the records pretty well speak for themselves on what the task force has tried to do and what the Ethics Commission hasn't done. As far as the motion itself, I'm in favor of it and support it. If you include the district attorney as one of the recipients, if the task force as a whole adopts the recommendation, then what is the district attorney going to do with it? Because the district attorney only deals with crimes. Can't go after anybody on the Ethics Commission with a paddle. So part of the inquiry should be, what crime do you think Mr. St. Croix has committed by failing, willfully failing, to discharge his duty as a department head? Thank you.
Thank you. Is there any additional public comment? Members? Okay. Mr. Clerk, would you call the roll call, please?
Yes, Madam Chair. Member Snyder?
Aye.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Washburn?
Aye.
Washburn, aye. Madam Chair, we have 5 ayes. The motion passes.
Mr. Clerk, would you call the next item on the agenda, please?
Item 7 is hearing on the status of the May 18, 2011 order of determination of Larry Littlejohn against the Sheriff's Department.
Is the respondent, or I mean, excuse me, is the complainant present? Okay.
That's Mr. Cisneros.
Mr. Cisneros, is the complainant present?
Excuse me, Mr. Cisneros, this isn't the complaint involving you. This is a different complaint.
Mr. Littlejohn. Okay. Is there anyone here to present facts and evidence in support of the complainant? Seeing none. Is the respondent present? Is there someone here from the Sheriff's Department?
Freya Horn.
Microphone, please.
Freya Horn on behalf of the Sheriff's Department. Also Kathy Gorwood from the Sheriff's Department.
You have 5 minutes.
I would just indicate that we have complied with the order. We've given 2 lists which were redacted of inmates, and we've given 2 of them, one on May 23rd and one on May 20th. We've also indicated that there is no policy. Part of his request was whether there was a policy not to provide such lists, and we've indicated that there is no such policy. I don't have anything further to add at this time.
Okay. Any additional? Okay. The matters with the task force for questions, comments, discussion. Member Snyder.
Is it Ms. Horn?
Yes.
You said that the records provided were redacted. Can you tell me what was redacted from the records?
Specifically, and I could have Captain Gorwood speak to that because she provided it.
What we redacted was the SF number, or what's known as the local ID number, which is associated with criminal offender record information, and specific housing locations, so specific cell or a specific bed.
But the names of the inmates were released as
Correct.
part of the list.
Correct. Names of the list and the jail at which they were housed on the particular day he requested.
Okay, thanks.
Mm-hmm.
Are there any additional comments?
Just a
Questions,
point of
discussion?
order.
Member Nate.
We have neglected to seek facts and evidence.
Oh, right. I didn't ask for if there was anyone else to provide facts and evidence in support of the respondents. Okay, seeing none, we're now asking questions and making comments and discussion. Anything, Member Nee?
Yeah, it seems to me that particularly since the complainant is not here, Mr. Rustum, have you received any communications from the complainant about whether he would or would not be here tonight?
Through the chair, I did not receive anything.
Okay. And having heard from the respondent, it seems to me that at this point, the proper course for us would be to declare this matter concluded, and if the complainant wishes to dispute it, he would have to bring it back and provide new evidence. His failure to show up here tonight and failure to communicate why he would not show up, it seems to me that kind of takes it off the table.
Okay. All right. If there's agreement on that, then do we need a motion to declare this matter concluded?
No, without a motion, if no motion comes forth, the chair can declare the matter concluded. However, I think in the interests of proper procedure, we should ask for any concluding remarks on the part of the respondent, also public comment.
Public comment, okay. Any concluding remarks?
No, none.
Okay, thank you so much. Is there any public comment on this matter?
Yeah, I would agree with Task Member Nee. When there is an order of determination and the complainant doesn't show up, you should presume that there's been compliance. So that would expedite the length of these proceedings. So I would support the motion by Task Member Nee.
All right. With that, I declare the matter concluded and asked. We decided that
There is no motion.
there is no motion.
Is there further public comment?
Is there any further public comment? Okay. Mr. Clerk, would you call the next item on the agenda, please?
The next item on the agenda is hearing on the status of the May 5th, 2011 order of determination of Andrew Cisneros against the San Francisco Municipal Transportation Agency.
Okay. Mr. Cisneros, you have 5 minutes.
Good evening, Task Force. First off, I'd like to thank the Task Force for granting me an order of determination for the records that I seek. I do have one question, and it's a 3-part question, bear with me. It's about this ordinance. If information regarding a record is withheld from a city and county of San Francisco agency or department, and that department or agency knowingly submits that as a record, is that creating a false record? And if so, is that a violation of the ordinance? Okay.
Reading from?
I'm reading out of my notes.
Oh, okay.
It's a question. I need to know if it's somewhere in the ordinance because...
Could you repeat it?
Okay. If information regarding a record is withheld by a city and county agency or department and submitted knowingly that it's a false record, is that a violation of the ordinance?
Through the chair, do you mean if they say they don't have it and they put that in writing?
Or they knew they had it, they had information about it and knowingly submitted it?
Knowingly submitted that they did not have it?
No, knowingly they submitted a false record. Is that a violation of this ordinance?
Member Wolf.
The ordinance is not based upon the context, but on whether the item is public or not.
Okay.
If the item has been declared as not disclosable, then it's not disclosable, whether it's the truth or not. If it's declared to be public, then it's public, truth or not. We're not here to judge whether the content or the context is factual.
As of the order of determination that was rendered In May, the MTA has not complied with the requested order of determination. I emailed Caroline Celaya on May 11th, indicating that I had not received anything and that I would like to resolve it before the Complaint and Complaints Committee met, but I've heard nothing. On June 13th, I received a letter, and I'm sure the task force has it in front of them, that the reasons why they don't comply. They're citing privacy and personal and privacy laws. But as we went through it before, there's nothing there that's personal privacy, that of a personal and private nature. It could be redacted. And Ms. Antonio gave testimony at that hearing that it was not a problem to draft such a paper. On April 26th, at an administrative hearing, Ms. Antonio gave testimony at April 26th, sworn testimony, and contradicted what she told you here. She said there was never that she had a call from Paul Williamson, but under sworn testimony, she denied it. So where are we at right now? I need that record. And the MTA just hides behind these personal and privacy laws, and that's where we're at right now, and hopefully we can find some resolution to this problem. Ms. Celaya still has not provided anything on the order determination. She cites California Public Records Act, but as a part of the Public Records Act, she didn't willingly give up the person who denied the request. She stated it as staff. And she said she would come back and give us the name of staff. She's not here tonight. The emails that Ms. Johnson had asked me prior to in the May 5th hearing, I thought I had them, but I never got them. As it progressed to June 13th, Ms. Celaya cites many case law, but I don't profess to be an attorney, and Ms. Celaya is not here to explain the case law that she cites. And there again, I'm left waiting for this material that was time sensitive. Thank you.
Thank you. Is there anyone present with facts and evidence in support of the complainant? Okay. The respondent, you have 5 minutes.
Good evening. My name is Ayn Antonio with the SFMTA. SFMTA disagrees with the SOTF's decision and order of determination and declines to disclose any of the records previously withheld for the following reasons. First, based on Admin Code 67.21, provides that custodians of any public record, when not in possession of the record requested, shall assist a requester in directing a request to the proper office or staff person. This provision, however, does not require the SFMTA to produce records which are exempt from disclosure due to employee privacy. The SFMTA declined to produce 5 records in its possession, which are personnel records for both Mr. Cisneros and another SFMTA employee due to privacy concerns. Although Mr. Cisneros signed a waiver releasing his privacy interest in these documents, he does not have the ability to waive the privacy interest of another SFMTA employee. And because these records in their entirety pertain to the other employee as well as to Mr. Cisneros, they cannot be redacted to protect the other employee's privacy. The SFMTA has no other responsive documents which have not been already provided to Mr. Cisneros. Further, there is no other city department which has any other responsive records. As a result, there was no violation of Section 67.21 of the Sunshine Ordinance by the SFMTA. Second, the SOTF found that the SFMTA violated Section 67.21b of the Sunshine Ordinance by failing to orally provide Mr. Cisneros the results of an internal investigation concerning the tampering with the drive cam equipment by SFMTA employees. No written report concerning the results of SFMTA's investigation existed, but SF Admin Code 67.21 does not require the SFMTA to create a record that is not already in its possession, and the California Public Records Act only requires an agency to make available to any person a copy of an identifiable record or records in its possession unless the record is specifically exempt from disclosure. The city's obligation under the Sunshine Ordinance, similar to the California Public Records Act, is to produce public records in its custody, not to create records that do not exist. Further, even if this non-existent record existed, it would be exempt from disclosure due to employee privacy. We further note that Section 67.22 of the Sunshine Ordinance requires that each department have a designated contact person to answer questions pertaining to the department's operations, plans, policies, and positions. Section 67.22b indicates that the contact person be available to provide information to members of the public who are not requesting information from a specific person. But in this case, there has been no allegation that SFMTA does not have a designated public contact person, and the department's obligation to provide oral information to members of the public, which obligation is stated in the general terms of operations, plans, policies, and positions, does not extend to results of specific personnel investigations, and certainly not in cases where if the information were reduced to writing, it would be exempt from disclosure. Third, SF Admin Code 67.26 provides that no record shall be withheld from disclosure in its entirety unless all information contained in it is exempt from disclosure under express provisions of the California Public Records Act or of some other statute. As previously noted, with respect to the documents withheld from disclosure, the documents are exempt from their disclosure in their entirety due to employee privacy. Regarding the video records, these records were used in the disciplinary proceedings for 2 individual SFMTA employees. Further, the SFMTA has neither the technological ability to blur or redact any image contained on the video clip, nor the obligation to obtain the technology to do so. Neither the California Public Records Act nor the Sunshine Ordinance require a department in possession of videotapes to purchase technology that would facilitate the blurring or redaction of videotaped images. As a result, the SFMTA has concluded that the Sunshine Ordinance does not mandate disclosure of these documents under these circumstances.
Thank you. Is there anyone to offer facts and evidence in support of the respondent? Okay, seeing none, the matter's with the task force. Member Wolf?
I do not find the MTA's response to be compelling whatsoever. I mean, reading just from the orders of determination, Ms. Saleha said that while the video may not be able to be blurred, no one could have any reasonable expectation of privacy being on a bus. So that, I don't understand that comment. Also, Ms. Antonio was, in her testimony at the hearing, said that she would ask Mr. Williamson to create the document. So here she's saying that under the guise of employee privacy, not stating any statute to show where employee privacy is being protected, I'm not compelled by that statement either. So I'm just not convinced that they've provided any information, that their excuses are unfounded.
Member Snyder?
I would agree. I think the letter essentially rehashes the arguments that the MTA's letter, that is, essentially rehashes the arguments they made at the initial hearing, and there were 2 records, 2 pieces of information that Mr. Cisneros sought, and the reasons that the MTA withheld those then are the same as the reasons that they're saying they need to withhold them now. we already went through all this and explained why those reasons, and I believe the order of determination explains why those reasons are not sufficient. So I agree with Member Wolf that the response today is not compelling, and I think further action is required. I'm not going to make a motion right now, however.
Any additional comments, questions of the respondent or complainant? All right, the first the respondent has 3 minutes for a rebuttal.
The SF admin code does not require the SFMTA to create a record that is not already in its possession, since it was a verbal discussion between Ms. Antonio, myself, and the superintendent. You know, we are not required to create a record that does not exist. So we're just not in a position to do that, from what I understand, based on advice from our legal department.
Thank you. Mr. Cisneros, you have 3 minutes.
There again, this is another version of the MTA dodge in the Sunshine Ordinance. There's no transparency at that agency. Mr. Ford left, Mr. Rohan left with big bags of money. Totally misconduct on Ms. Antonio's part, where she gave sworn testimony at an administrative hearing saying, no, there was no conversation with Paul Williamson. I have it right here, stenographer notes. She comes over here to the task force and says, yes, there was, but we don't have a report. That report exists somewhere. They're covering up for their own misconduct. I'll read from the court reporter's notes. Mr. Schwartz, my attorney, did you ever speak to Mr. Williamson regarding what investigation, if any, conducted after you asked him for a report of the incident on October 5th? Not that I can recall. That was an administrative hearing. These are notes that are going to be used against me. And here she says, there was a conversation. There was no tampering. And yet Ms. Antonio at the previous hearing says it's the way we did the charges. I have the charges here. That was one of the charges: tampering, dishonesty, inattention and duties, which we all shot down at that administrative hearing. Mr. Cohen can't even make a decision right now because of all the issues I've raised. I would hope this task force really puts the screws to the MTA right now, because what they're doing is covering up for their misconduct. Thank you.
Thank you. Matters back with the task force. Member Wolf?
I would just like to remind not only MTA, but other people that are, including ourselves, obedient to the Sunshine Task Force, the Sunshine Ordinance, that 6722B requires oral help where there is no document, and to help the member of the public to find them. So it's no excuse that if there is oral discussion, you might not be required to make a document that doesn't exist, but you got to have the oral discussion about it. And if there is no information that you can provide orally, then you must at least try to help the person find a place or direct them to a place to where they might be able to get it. And sans that, send them to your superior. And if the superior doesn't know, send it to their superior, and so on and so forth. Ultimately, the people that are the most responsible for the Sunshine Ordinance is our elected officials and the department heads. So with that, I would move to find, for all that is listed in the order of determination, and to find, well, I don't know what, The question is whether it's Ms. Celaya or Ms. Antonio that is the direct responsible person at this point. I don't have a title for any of these people.
The letter of June 13th.
Oh, here,
is signed
Ms.
by
Celaya
Celaya.
is assistant to the MTA's board secretary.
I believe,
Member Snyder.
I think if I remember correctly, Ms. Celaya testified that she also acts in the capacity of sort of a custodian of records for MTA. I may be remembering that wrong, and if anyone else remembers differently, please
For these
correct me.
particular records?
I think generally.
There's no one custodian of records.
Yeah, I think
everybody's a custodian.
Well, I think she testified that she acted in that capacity generally for the MT or for the.
So did David Hill. Remember, they tried to say that if you didn't send the sunshine request directly to Ms. Celaya, that it didn't count. David Hill said that she was the person who was designated to receive sunshine requests.
Right, that's right.
All right, so I need some help here. Who are we? Who's this being focused on? Can't focus it on an agency.
Ms. Celaya.
Okay, if we focus it on Ms. Celaya, she realized that she is not in a managerial position, so it cannot be referred to the Ethics Commission. You can take it up the line if you want, or what we can do is we can recommend that the violation be sent to her superior, and her superior demand enforcement, that we demand enforcement by her superior, and then if we find that the enforcement has not been made and that person is in a managerial position, then we'll take that up at a later date. What do you think? Okay, so we don't know who her superior is, do we?
Member Nate.
Ms. Antonio? Could you please tell us who is, to whom does Ms. Celaya answer?
I am not really sure if she's noted here as the, I guess the assistant to the board secretary. That would be Roberta Boomer. But I'm also wondering if I really don't know if she should be under Donald Ellison, who's in charge of the Human Resources Department. So I'm really unclear at this point. I'm sorry.
Well,
I have a possible solution. Let's just find in violation for Ms. Celaya, and then with the recommendation that between now and the time that the next board meeting, the next Sunshine Task Force meeting, where this will be decided, that we'll have our administrator track down who exactly the chain of command is with regards to this line of employment.
Member Johnson.
The only
point of order. Motion has not received a second.
No.
Were you making a motion or asking a question?
I moved that we find all the items in the order of determination and find with reference to Ms. Celaya, and that a request be made to her superior, her manager, to carry out enforcement.
Whether I should second it to ask my question?
Member Nate?
Yeah, just in answer to that question, it is possible to second the motion for discussion purposes.
I'm going to second it for discussion purposes, but my only real question about it is Ms. Zelaya is the administrative part of who is supposed to distribute the sunshine requests, but it's the human resources side that's saying they cannot give. So I didn't know which path was the more appropriate for the sunshine ordinance. Otherwise, I totally support the motion. Just which path is the best? Are you saying we don't know? That's a question.
Again, I asked the question. I asked for some help as to who this should be focused on, because throughout the entire, the only two people that have shown up here is Ms. Celaya and Ms. Antonio. So the question is, it's one or the other that's supposed to be providing the documentation.
Because the Ms. Boomer is up through the board, but then
She's not party to this.
Well, but she's Ms. Celaya's direct supervisor because she's the the MTA board secretary. We don't know that for sure, but
is she employee though?
That path is, toward the board, and we're dealing with the MTA's real workers.
Right. We're dealing with the administration side.
So should we go that path first?
Administration side.
Yeah,
Okay.
why don't we do
Okay.
that?
This is dealing with an employee issue. The employee's not asking the commission, the MTA commission is not, the complaint's not asking for information from them. It's asking information from the administration. Now, the commission can compel the administration to give them
But
the information.
I feel like
but-
you're going down the path of the commission with Ms. Celaya, but maybe
Well,
wrong.
that's why I asked, because the issue here is is against the agency, not against the commission, not the MTA, not the MTC, the commission itself. I don't believe that was the thrust of Mr. Cisneros' request. He was asking for information specifically from employees, investigators, so on and so forth, and that he was asking for administrative relief, not necessarily policy or legislative.
I have a suggestion to move the agenda forward. Let's take public comment on this motion, and we might learn something from members of the public. Member Nee.
Could the motion be repeated, please?
The motion is to find, at this point, Ms. Zelaya in violation of all the items that are in the order of determination, sections 6721C, 22B, 26, and that a request be made for enforcement by her superior or department head.
All right. At this time, I'd like to hear comments from members of the public on this motion.
Good evening, Task Force. My name is Dorian Maxwell. To answer the question that you have, who to send it to, Deborah Johnson is at the time before she became executive director after Ford and Rohan left, she was in charge of the administrative side. So I think you need to refer her as the person of interest in this matter. Also, you need to make recommendations that Ms. Antonio goes to the Ethics Commission for willful misconduct on behalf of testifying at one administrative hearing saying that they didn't have a conversation with Mr. Williams, and then she comes here and tells the task force that she did have a conversation with Mr. Williams, and there was no point of any tampering of the camera on Mr. Cisneros' behalf. And she did testify because I sat in the room when she was testifying before the task force. Another thing needs to be addressed. As you can see, that the SFMTA has willfully sidesteps the law of passing the buck from one person to the other instead of holding accountability for their own actions of misconduct. They cover up their misconduct by passing the buck along to one person to the other instead of owning up to responsibility. I do recommendation that you do send something to the State Attorney General office and have them launch an investigation on the operations of the SFMTA in respects to how they're facilitating discipline towards their employees and harassment towards their employees. Since I've been coming here to testify on behalf of other employees, and I've been retaliated against. Now I'm up for dismissal because I came here asking for an email train that exonerated me, and Mr. Hill was submitted to the Ethics Commission for misconduct. Now he's instructing Ms. Chambers to fire me. So that needs to be addressed, and a letter of recommendation needs to go to the State Attorney General's office on how they proclaim their activities on a day-to-day basis in respects to their daily operations, because there's a lot of misconduct going on in the SFMTA that needs to really be addressed. Thank you.
Thank you. Is there additional public comment on the motion?
I just want to clarify something that I think may have been misunderstood. The enforcement power says the task force shall make referrals to a municipal office with enforcement power under this ordinance or under the California Public Records Act and the Brown Act whenever it concludes that any person has violated any provisions of this ordinance or the act. So you don't need a department head or a managerial person, employee, to send it to ethics, because once ethics gets it, then their own rules will determine if they find that there is a failure to comply with the ordinance, and they have their own remedies for that. You know, they can fine them, or I think they may even be able to suspend them. It depends on their own rules. Thank you.
Thank you. Additional public comment?
Thomas Piccarello. Yeah, I agree with Alan's comments that you can refer violations to the Ethics Commission without you alleging a serious and willful violation, because then you have those categories that you have to put these people in. But, you know, looking at this case, this is a reoccurring issue, isn't it? In that you haven't gotten to the right person, so this conduct will stop. How many hearings will it take before you figure out that the process you're using is not being effective? Mr. Cisneros requested records in February. He doesn't have them. And now you're going to refer this back to the full task force with a finding that you claim the person has violated your order. The person that you're going to name, Ms. Celaya, has sent you a memorandum saying she doesn't have to comply with your order. You don't know what you're talking about. So if the purpose of this hearing is to get Mr. Cisneros his records, your order or your motion is not going to help him. So when the full task force makes rulings, you need to get the right person so that there'll be an effective compliance. Because, again, what's at issue is Mr. Signeris wants his records. He's been asking him for February, and you're not helping him at all tonight. Thank you.
Thank you. The matter's back with the task, excuse me. Sorry, Mr. Pitts.
Well, I have a problem with the item as well. When I do my information requests, I don't talk to her at all. I talk to the department heads. When I file my information request, I send it to Nate Ford, and then Nate Ford can figure out who and where it goes to. So you'll list somebody who's her superior, and then she'll say something, and then you'll go to her superior, and then you'll go to that person's superior, and it might take you another year or two to finally get the information if they get it. I mean, I always start at the top and work my way down. If the person who held Nate Ford's position can't get him his information, we're in serious trouble.
Thank you. Is there any additional public comment? The matter's back with the task force. Member Wolf.
Yeah, I would just like to ask member of the public, Mr. Grossman, what section he was reading from. C.
Madam Chair?
Member Ning.
Yeah, it's about halfway down that section. It says the task force shall make referrals to a municipal office with enforcement power under this ordinance or under the California Public Records Act and the Brown Act whenever it concludes that any person has violated any provisions of this ordinance or the acts, meaning the state acts.
Okay. Then I don't understand. 6734 and 6735. I mean, it seems like it's complete in light of 6030C.
Member Ning.
Well, I think a distinction that the Ethics Commission has made is that 6734 pertains only to elected officials, department heads, or other managerial city employees. Ms. Celaya is not a managerial employee.
Right, so then, based upon that, if we were to use the suggestion of 6730C, what other enforcement department would we send this to?
Member Snyder.
I believe we can still send it to the Ethics Commission. The 6734 is just for willful misconduct. We would be finding a violation, but we wouldn't be finding willful misconduct if we were to refer it to the Ethics Commission for violation by Ms. Antonio or Ms. Celaya. If we wanted to find willful misconduct, which I think has higher potential penalties, then it would need to be a department head. But we don't have to have a department head to refer it to the Ethics Commission or to other city agency.
Granted, okay, so the process is there. What do we hope the enforcement to be at that point?
That I don't know. I don't know the answer to that.
What do you expect the enforcement to be? What do we want? What are we requesting the enforcement agency to do then? What should we have them do?
To have them produce the records that Mr. Cisneros is requesting.
Okay.
That's what this is all about. And it's
Okay,
taken
so
a
we
very
are
long time.
asking I'll throw this out there. We can have more discussion on whether it's correct or not. I'll amend my original motion to recommend that Ms. Celaya be referred to the Ethics Commission, and that the Ethics Commission shall provide enforcement to produce the documents in question by the complainant. Let's start there.
Does the second accept the
Yes.
amended? Okay.
Yes.
Member Nee?
Well, I have a couple of questions. First of all, does your amended motion, does the amendment you move substitute or append the original motion?
It'll replace my original statement that it go to the department head.
Okay, so the motion now reads to refer back to the full task force with
a recommendation to
refer to the ethics.
to refer to the Ethics Commission Sunshine Enforcement Division to have the Ms. Celaya et al. MTA produce the documents that the complainant Andrew Cisneros is requesting.
At this point, we'd like to hear comment from members of the public about the amended motion.
Yeah, I strongly support that motion, and I want to thank Mr. Grossman for pointing out that you can refer things to the Ethics Commission without a serious and willful violation. Thank you.
Additional comment?
I think you should amend the motion and add Ms. Antonio in there because she's in a managerial position. She's the superintendent of the division, so that's considered a managerial position.
Maker of the motion?
Excuse me.
Excuse me.
We're in public comment now.
I'm sorry. Is there additional comment from members of the public? Seeing none, the matter's back with the task force.
Yeah, as far as I'm concerned, and reading from the minutes in my memory of this particular case, it seemed like Ms. Celaya was the one who was in most control of the information flow and was the one pulling the strings on what information was going to be released or not. I don't know about adding Ms. Antonio to the recommendation at this point, because she was, as far as I was concerned, she was just well, I don't know. I need a moment.
Member Nee?
I'd like to call the question.
Mr. Rustin, would you call the roll, please?
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Wolf?
Pass.
Wolf, pass. Member Johnson?
Aye.
Johnson, aye. Member Wolf?
Aye.
Wolf, aye. Member Washburn?
Aye.
Washburn, aye. Madam Chair, we have 5 ayes. The motion passes.
Mr. Clerk, would you read the next item on the agenda?
The next item is hearing on the status of the May 24, 2011 order of determination of child spits against Supervisor Jane Kim.
Is the complainant present? Yes. Sir, you have 5 minutes.
Well, maybe I missed it, but I still believe I haven't received any of the I haven't received the information that I requested. I had requested phone conversations, not conversations, but like some type of documentation of who called her about the appointments and stuff. And then I also asked for a copy of their calendar as well regarding it, and I haven't received anything from them.
Thank you. Is there anyone here to offer facts and evidence in support of the complainant? Okay, seeing none, is the respondent present? Sir, you have 5 minutes.
Good evening. For the record, my name is Matias Mormina. I'm a legislative aide with Supervisor Jane Kim. We have no further record, including no phone record, calendars, or letters that Mr. Pitts is requesting. He did, at the full task force hearing, mention that he was looking for documents provided by Bernice Casey, who's a staff person at the Shelter Monitoring Committee. We had originally provided 7 emails, conversation, and 1 attachment, which should be in your packet, which was page 30 of the information that we provided. And that is everything that we have on record for the moment in which we responded to the immediate disclosure request. Addressing the fact that the disclosure request wasn't addressed in a timely manner, we now have 3 different people scanning records of the supervisor's email, including the supervisor herself, 1 of the legislative aides, and 1 of the intern on a daily basis for any IDRs. Hopefully that will help us with more timely response and compliance to the Sunshine Ordinance.
Thank you. Is there anyone else here to present facts and evidence in support of the respondent? Okay, the matters with the task force for comments, discussions, and questions. Member Snyder.
My recollection of this case and my reading of the order of determination is that the issue here was that Supervisor Kim's office didn't respond in a timely fashion to the IDR. And so the violations that we found were for a failure to respond, essentially for a failure to respond timely. We also found for a failure to justify withholding, but that was sort of an addendum to the core finding that it wasn't timely. And I'm not sure so I suppose at this point we could try to take issue with the fact that the supervisor's office claims there are no further records, but I'm not sure it's our place to re-adjudicate that issue. I'm not sure there's anything further to do on this. They ultimately produced the records being sought, if I remember correctly. The issue was timeliness.
Member Johnson.
There was one of the issues was that there were some letters that were turned over to the Rules Committee that were not produced by any of the supervisors. And when you're in your absence, we had quite a discussion with Supervisor Ellsburn, who was the 3rd supervisor that documents were requested from, and he claimed his office did not keep those letters. There was a handful of letters that were turned over from varying agencies directly to, not our Rules Committee, but the Board of Supervisors Rules Committee. And the complainant had actually offered to show us a video of it, but I had watched it. So now I don't know if we want to ask. They're saying they have no additional documents. I don't know if that ends it, as far as our recommendation, or if we want to ask if they keep those records or if they rely on, one of the things we asked Supervisor Ellsburn was if he had tried to direct the complainant to where those documents might be kept. And it was his testimony that the complainant, his office had tried to contact the complainant but could not. So I don't know if you want to go down that.
Chris?
Madam Chair, the documents that I looked at the Rules Committee video, and I did see Bernice Casey handing over a set of documents. The clerk's policy is whatever's handed over at the meeting goes into the legislative file. I told Mr. Pitts about it, and I gave him the file number, and I told him if you want a copy of it, you can get it from the clerk's office.
Okay, thank you. Member Johnson?
Was that after our hearing or at the time when Mr. Pitts first filed the complaint?
Through the chair, it was after the hearing.
Okay.
Because it was then only that Mr. Pitts said there was a video.
Thank you.
Okay. Member Wolf?
Yeah, so it doesn't, it doesn't obfuscate the relevance of the case. The fact that the information is available to Mr. Pitts and he can get it now is after the fact. We're dealing with what the facts are at the time that the complaint, the purpose and the reason why the complaint was made, and the actions that happened or did not happen prior to that complaint. So I think, along with Member Snyder, I think just all the items, if according by Mr. Pitts' testimony, he has not received any additional information. Well, let me ask Mr. Pitts. Let me ask you a question. What additional information are you expecting to get that you know exists?
Well, one thing about it is someone had told me that somebody called James Kim office about the recommendations regarding the shelter monitoring company. So somebody told me that there was.
Is that person here today?
Well, I don't think it's wise. Well, considering they work with Jane Kim, and that Jane Kim would probably fire them if they said anything.
Well, there are whistleblower.
Oh, the guy, the whistleblower who got fired, both of them, the two whistleblowers that got fired, and they've been working for the city and county of San Francisco for 2 years.
I understand.
Okay, so of course I'm not gonna out him, but
I know, but this is a matter. We're dealing with a matter of law here, and trying to work on hearsay is really difficult.
Okay, well,
so
I asked for documentation. I didn't get it. And the thing is in that video, in that meeting, Jane Kim, Sean Esmanern, and Mark Farrell, they were looking at whatever these documents that were being passed around. And then they kick them back to somebody else, and then they say they don't have them. So they were in custody of these documents.
Okay. Thank you. Mr. Mormino. So we just heard our own staff who has reviewed the video of that meeting, that there were documents that were distributed to each of the members of the Rules Committee. Were any of those documents provided to Mr. Pitts?
We don't believe, or we don't have a record of these documents. When they were handed over to the supervisor, they were later discarded. We don't have a record of what those documents were. As your staff person.
Okay. So you realize there's a retention policy for the Board of Supervisors?
I understand that the situation is we don't have any record of those documents. The supervisor has no recollection of these documents. So
the supervisor does not remember being handed documents during the meeting.
She doesn't remember the content of those documents,
Just remember the content documents.
which is what the information disclosure.
Okay. All right, thank you very much.
Member Johnson.
I understand that you turned over the emails, but are you now aware as a legislative aide to that supervisor's office that one of the things that might have helped Mr. Pitts is if you had stated what our staff stated, that the clerk is required to keep the documents, and that's part of your role as the Sunshine, under the Sunshine Ordinance, to help them locate the place where they might find those documents?
I am now aware of that.
Because it would be great if you would implement that with your interns, because it would, that way people could have access, even, you know that there's a process, and people don't really know that.
Okay.
Thanks.
Any further questions, comments? Excuse me. The respondent, you now have 3 minutes for a rebuttal. The respondent?
He says no comment.
Okay, no comment? Okay, I'm sorry. The complainant?
Yeah. So what the respondent is saying is that Jane Kim doesn't have a calendar, and almost like nobody calls her regarding these appointments. That's kind of like what he's implying. Regarding Chris and what he's saying, all he gave me was an office and a number, and it's kind of perplexing to me as to where I'm supposed to go and what I'm supposed to do to get these documents if I get them. So it really didn't help me, him giving me a number and giving me some title to get documents. If anything, Jane Kim and her people should have been giving me that information. And she has a responsibility to help me get those documents.
Okay, the matter's back with the task force. Member Johnson.
It's a difficult conundrum. If they're saying they don't have the documents, that we can't make them turn them over, and there's no evidence that their office themselves keeps the documents. After our hearing with Supervisor Ellsburn, I did a Sunshine request for their document retention policy, and I really feel that it's something that the task force might make a recommendation in a letter to the Board of Supervisors that this idea that you can discard things before the matter is totally, that there should be some period of time during which things are kept, or a history of it in some way. Now I don't know about the calendar part of it. I know there was no calendar turned over. But I do think that if we, rather than simply concluding it here, we definitely should at least make a recommendation that these are still matters, that the public would be interested in, and that just simply deleting it, not knowing if the clerk has it even, there has to be some kind of retention policy.
Member Wolf?
The only thing I can say, despite those other records that they may have thrown out, destroyed, misplaced, don't know about, can't produce, what have you, the question with regard to the calendar, Prop G calendar, is still on the table. And that has to be produced. That's something that 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 cannot be withheld. So I'll leave that on the table for the moment to hear more comment.
Member Nate?
Prop G calendar does not include supervisors. That was an omission, an erroneous one by the drafters of Prop G, but supervisors are not there.
Interesting.
Member Snyder?
And moreover, I'm not sure we ever addressed the issue of the calendars in the initial hearing on this. I don't see a mention of it in the OD, and I also don't remember it myself, which doesn't mean it didn't happen, but I'm not sure that which is to say this could be adjudicated later, but I don't think we addressed the calendars in the full task force hearing on this.
Okay. Yeah, I do remember it was emails and other documents, but I do remember a list of requested items, and there was a request for communications, calendars, communications, meetings, things like that, which under the retention policy they're supposed to be keeping. A list of visitors, a list of phone calls, not the actual emails, but a communications log of emails that are received. That's something that the task force is going to take to task as a general item onto itself. How it applies to this particular case remains to be seen. The questions here, though, is what documents were received and were not received. We can't. I don't know if we can. We know of. I can only know of one document, the set of documents that our staff has reported having been seen, handed to the supervisors. We have yet to hear from the other two cases to know what they may have or have not. So that's the only thing that I can focus on. Anything that beyond that we don't know exists at all. So if that is the only document that our staff says that exists that Mr. Pitts did not get by his request at the time of the request, then that's the only thing I think we can move up, take action on.
Mr. Rustam.
Madam Chair, could I clarify one thing there? In the folder, Bernice Casey handed over the folder to the clerk of the Rules Committee, and she took it and placed it on the table. That is what the video I saw showed.
So So you're saying now that the Bernice Casey handed a document to the clerk.
Yes.
And did the clerk distribute that to the supervisors?
That is the part. If she did it later, I do not know. But what I saw was she took it and placed it next to her.
Okay, so we don't know if the supervisors actually got those documents.
I did not watch through the chair. I did not watch the video from the very beginning to the end.
Okay.
Member Johnson?
Again, I don't want to re-adjudicate it, but who would then verify it? Those documents were part of they weren't just like letters of recommendation, they were requirements, same as our requirements, like that Member Snyder has to be an attorney. So they were requirements. So I'm not sure is that something that the clerk would normally prepare for them, or did it's tough because there's
Mr. Mormino, let me ask you a question. There are since Supervisor Kim is the chair of the Rules Committee at this time, when it comes time to have discussion or an item comes before her with regards to appointments, how are the applications handled? And are the applications retained within her office? And if so, after the matter has been dealt with, what happens to them?
So the usual procedure is the clerk of the Rules Committee prepares a packet for the chair and other members of the committee. The packet is readily available online and includes any documents, the application and any supporting documents that both the applicants or third parties provide.
But what do you retain in your office?
So we don't retain that once the meeting is over. We discard the full packet that is prepared by the Rules Committee.
You discard the packet?
Correct.
Because it is now in the hands of the clerk?
It is now in the hands of the clerk, and it is available on the website if we need to further consult that.
If there were, the issue here is if there were handwritten notes, if there were additional documents that were received that were not included in the packet delivered to the clerk for preparation of the Rules Committee meeting, but that were maybe personally or that were sent or omitted or anything like that, but in the possession of the supervisor, that is what Mr. Pitts was asking for. So
I understand. It is a matter, we got a reminder of this as of today, that any matters that come directly to our office that are not directly addressed to the clerk of the board should be forwarded to the clerk of the board.
I understand, but for the purpose of this order, we're asking now, are any of those documents available?
In addition to what we have provided, I have no knowledge of any additional documents existing.
Okay.
And if you want me to address the calendars and phone?
If you would, yes.
Yeah. So we did not disclose any calendar and phone record because on a matter of calendar, we did not have any meetings regarding this item on the supervisor staff or the staff's calendar, and we do not keep a detailed phone log, and we did not have any notes regarding any phone conversation that had happened in regards to these appointments.
Thank you.
Excuse me. In the video, it said that Jane Kim had met with several of the candidates. In the video, it says that, and now it sounds like he's just saying something different. So, I mean, if you need to recess and then look at the video and go from there, that might be necessary. And see I submitted after the first hearing that they recessed the agenda item. I submitted like 3 other letters and a letter just saying this is me and these are the other documents. So I didn't even get those back. So it's like, I mean, I have it stamped, but I didn't bring it with me. But there's more documents out there. If anything, just the documents that I submitted. So I submitted letters saying from other people saying, this would be a good candidate. I didn't even get those back. And then the other thing too is I believe Bernice KCD said something about the local homeless coordinating board when not the local homeless coordinating board, the coalition on homelessness, when she gave those documents to the Rules Committee. And see, in the meeting, they had those on their counter. They were all looking at them. So they received more. They received more than what he's implying.
Mr. Pitts, let me just ask you: have you received any documents from Supervisor Kim's office?
Not that I know of. After those emails, after
you
those
have
emails,
to either know or not know.
Okay, what I'm saying is, after those emails that I received from her, that was it. That was it.
So all you received were those emails?
Yep.
You didn't receive the documents that you had submitted yourself?
Nope.
Okay. Did you go to and get the documents that are retained in the clerk's office?
all I got was a number, and I don't even know where the clerk's office is. So, I mean, part of it is under the sunshine, you're supposed to give me documents, not ambiguous numbers.
Well, we can help direct you, yes. We can help direct you where to go, and the clerk's office is in the building. You know, it's...
This building has 4 stories and is big.
There are directory signs on the walls. I mean,
All I
I don't
got was
want
a
to.
number.
I'm not trying to be disparaging. But at a certain point, you know, there's an office for that. All I'm trying to find out is if you can find some corroborating evidence.
How come I couldn't get this from Jane Kim?
Listen, if you can find some corroborating evidence that here's this packet of documents that is now with the clerk from that particular meeting. You received a set of emails from this particular supervisor or any others. What is then missing between them? And that is what we're dealing with here. Now, we can't, you know, we're trying to do our best to compel them to produce something. Okay, if they say that they don't have them, then what? But I'm not going to re-adjudicate the entire case here.
I mean, I understand that, but they have the right to take a document, read it, and then destroy it, and then say they, you know,
if
we
their
don't have it
retention
anymore.
policy says that they can do that, then yes, they can do that.
So, like, within 24 hours of receiving the document.
In some cases, in their retention policy, yes, it does say that.
Okay, so that's...
But I don't know in this particular case for those particular documents. You asked for a lot of different documents,
and they haven't provided them
Oh, they're saying that they don't have them.
because they destroyed them.
but you did receive some emails.
I received some emails, some just emails, and
Okay.
it wasn't even. I mean, the phone log. I didn't receive anything. You know, and somebody told me that they would call. They called Sean Ebernez. Chances are they called Mark Farrell, whatever his name is. I mean, I didn't receive. All I got was some emails that were.
Okay, because we're going to have this conversation 2 more times tonight. We're going to more or less have the same conversation.
time tonight.
Oh, one more time?
Mhm.
One more time tonight. So, you know, I just want to make sure that we get to we're able to provide you with the necessary justice for this particular case so that we can move on to the next one and that we get the right thing right.
Well, I mean, it's very clear. I asked for information, and she refuses to put forth the effort to help me get those documents.
Member Johnson.
In making a sunshine request, unfortunately, as it evolves, it's going to require some responsibility on your part. And so, for example, I really wanted to be able to have a discussion with Supervisor Ellsburn about him trying to talk to you about getting the information about where the documents were, since he was so adamant about having deleted them. But he could not. I would represent that Supervisor Ellsburn is a very direct person, and he will just contact you and call you right back and walk right up to you if he wants to. He's very direct, and that, in my experience with him, that doesn't mean I always agree with him, but he's very direct. So if he can't get a hold of you, then it's difficult for us to determine what he would have done. And
well, see, that's
Jane
not
Kim,
true. It's not true. I mean, I came
if he
up there.
cannot get a hold of you, it is not his responsibility to chase you down under the Sunshine Ordinance. There may be other responsibilities, but we do not have jurisdiction over it. In addition, if you refuse to go to the clerk's office, Jane Kim is not required to go there for you.
Well,
Now, their office admitted that they perhaps should have known to direct you more quickly and more ably, and that's true, and he admitted that. But there's still a responsibility for you to go to the clerk's office. You can't just say that you can't find it in the building. I would like for them to take the initiative, as you would. I would like for them to take the initiative to perhaps send them to you, especially as chair of rules. But we can't make them do that. That's all I'm saying.
Well, Well, Sean, I came in, I did come and pick up documents from him.
Madam Chair, it's not germane to this particular
Right.
case.
I mean, but the
This-
point is that he came there and just lied, like he's like all
I know, but
politicians.
that's
are
not,
truthful,
we're not
right?
talking about Supervisor Ellsburn here.
Mr. Pitts and everyone, let's focus on this particular agenda item. This is regarding Supervisor Kim's complaint, or the complaint against her. So let's focus on this. Right now, we're at the point in the deliberation where the matter is back with the task force for consideration of what we're going to do next. So,
You going to make a motion? Okay, so
Member
I
Wolf.
move to find a violation of 6725A, not responding to an IDR before the close of the next business day. That's pretty obvious. 6721B, by not responding to a request for information in a timely manner. Same item. 6727, by failing to justify the withholding. Obviously, just not knowing what to do or what to provide as far as documents. And referred to the EOT.
excuse me, Member Wolf, we decided that, those were violations, but this is all about compliance. So I think we should focus on that. And so you can't comply with something that's water under the bridge.
Okay, so, well, those have already, right, they've already been, well, I don't know.
Do you have
Somebody else, I don't have anything else to say.
Is there some part of that that would make sense to refer to the EOT, is what I'm asking? Member Johnson?
I would make a motion to, there's a motion on the, was that a motion? Do you need to ask for a second?
It's not a motion.
I would make a motion to recommend to the full task force that a letter be sent to the supervisors addressing this problem about their deleting of emails and emphasizing I'm sorry, the section is escaping me, but emphasizing the section that requires them to assist. Is that 6721? C. And detailing, in detail what that means, not just that it's to assist, but sort of an education, outreach, and training letter.
So should this come from the chair of the full task force? This should go back to the full task force.
The full task force. We
discussion.
may have the chair of the Education, Outreach, and Training Committee, or I don't know, but the full task force could decide just to demonstrate that this is an issue and that it raises big concerns about their document retention.
Okay. Do I have a second? Member Wolf?
I'll second it. The only thing I have to say is that I'm it's kind of, for me, it's premature because I am still reviewing the retention policy and determining what the Board of Supervisors are required to do and what each supervisor is required to do with regards to their as being committee members versus what they do individually as supervisors. I mean, there's a lot of information there. It's a very long list of documents. And so, by somebody requesting communications logs, that has one set of rules versus appointment applications has another set of rules. And so it makes it very difficult to know, except to say that they didn't know what it is or what they were doing. So,
Well, I could amend it to address only 6721C, the necessity to assist the requester with where the documents are, or to, in combination with narrowing down the request.
but we're here to determine what the disposition is at this point. It's already been adjudicated, so what do we want the task force to do? How do we want the task force to dispose of this? Do we want her to go through another sunshine training and her entire staff? Do we want to find her in violation of willful failure? Do we want to, what is it that do we want to do? Should we dispose of this? That's what I'm having trouble with, because the information, I could see the IDR part, okay, you know, and not responding in a timely manner. We've dealt with those things before, okay, and those, I believe, have gone to EOT.
And in fact, Supervisor Kim's office has put measures in place to ensure that this type of thing doesn't happen again.
Well,
so
let them bring that to EOT and let EOT determine whether it follows the letter of the ordinance, and any other supervisor that this may fall under. You know, as far as being able to produce certain documents, if they didn't produce the documents they were supposed to produce, then they should produce them.
And they don't have any other documents.
They don't, okay. If they don't have them, then they're in violation of their own retention policy.
We were the ones saying that we can't say that to them, though. That it's premature, not that we can't say it, but that you feel that we need more information.
Right, that's why it's this is making it very hard for me.
Member Snyder.
I would just add, hopefully it's helpful, we don't always have to do something. I mean, this committee doesn't have to do anything or recommend anything, and I would go back to what I said at the outset, which is that I'm not sure there's anything to do here. I think the order of determination speaks for itself. I don't think there's really any follow-up. I like the general concept of a letter, but I also agree with you, Member Wolf, that it may be a little early to do that before we know what's required of retention policies and so forth. So I would just reiterate, I'm not sure there's anything to do at this point.
You can do 6720C, what we did the last time.
6720C is definitions. You mean 6721C?
21C.
I
Oh,
mean,
I'm sorry, is that?
So this motion was made and seconded. I'm losing track as to where we are.
6730C, I meant.
At this time, I welcome public comment on this matter.
Microphone, please.
I'd request that when you do speak, you speak in the microphone so the members of the public can actually hear your discussions. Supervisor Kim would have you believe that as the chairman of the Rules Committee, appointing 3 members to the Shelter Monitoring Committee, she did not speak to anybody, she did not talk to anybody, and she doesn't have any documents. You failed in your responsibility to challenge what Mr. Mormino is telling you today. You cannot just accept a supervisor telling you he or she doesn't have any documents. You got to use common sense. You don't need a legal education. This is a lawyer. This is a chairperson of the Rules Committee who had 2 sessions as appointing members to the Shelter Monitoring Committee. When Mr. Pitts testified, there were 5 people that testified for him. He received 5 letters of recommendation that he sit on the Shelter Monitoring Committee. Yet he was denied the right to sit on the Shelter Monitoring Committee. Mr. Pitts wants to just reasonably know why. Why? You know, there's a reason we have a hearsay rule in our judicial system. It's not credible or trustworthy. Mr. Rustin told you that Bernice Casey of the Shelter Monitoring Committee handed over to the supervisors, where he says to the clerk, but I was there, The documents were handed over to the 3 supervisors. They all had a stack of documents. None of the documents were produced by Supervisor Kim, Supervisor Elsberon, or Supervisor Farrell. Your order of determination, you need to read it. Since the order of determination, Mr. Pitts has not received anything. The only emails that he received were emails from other candidates who decided not to run for an appointment on the Shelter Monitoring Committee. He didn't receive any emails regarding conversations regarding the process or why he should or should not sit. She is not telling you the truth, and it's your responsibility to figure it out. Thank you.
Thank you. Is there any additional public comment?
I find it ironic that we're talking about the Rules Committee that heard all of you talking about what a great candidate I would be for the Ethics Commission, and they managed not to move my candidacy forward. And we know why. And I think what's going on here may be a subset of that, but there is a section that has not been discussed, and it's 67(9)A. Agendas of meetings and any other documents on file with the clerk of a policy body when intended for distribution to all or a majority of all the members of a policy body in connection with a matter anticipated for discussion or consideration at a public meeting shall be made available to the public. If I wasn't there, but if somebody handed the clerk of who's sitting in the spot that Mr. Russum is in relation to the Rules Committee, and then that clerk distributed those out, this section covers it, and it's a public record, and it should be retained because it goes on to say, and they should be made possible, accessible through their website. That's even more. Anyway, they're open for public inspection and copying upon request. So if they actually got them and all 3 supervisors trashed them, 67(9) A, B, or C may apply. Just a thought. Thank you.
Member Wolf.
So, thank you, Member of the Public Grossman, for mentioning that. The question then becomes, and whose responsibility really is this? Is it the supervisors or is it the clerk? The clerk, if the clerk was handed the documents, the clerk has a responsibility to uphold the Sunshine Ordinance and to distribute those documents accordingly prior to giving them to all the members. They hand some to the members and they put some on the table. That's so where's the culpability then supposed to lie upon? If the documents were distributed during the meeting and not prior to the meeting, and they walked out of the meeting leaving the documents on the dais, like right here, I get up and walk out, I don't take them with me, then they don't have access. They don't have them in their hands. It's not in their possession anymore. Okay? That's another factor. We don't know. Okay? Now, if you want to continue this, you want to go watch the videotape, which is available, so we can see exactly what happened, and if there are documents that Mr. Pitts should be privy to and have that he didn't, or frankly, the entire public should have had that didn't get, there you have another situation. But then maybe the focus of this is on the wrong parties. Now, the information that Mr. Pitts is asking for is specific. That usually happens behind closed doors. And if there was admission by Ms. Kim that she had met with members of the applicants prior to the meeting, but there is no record of that, then there is a violation of what? Okay, the question is orally, did you get that information? If you got it orally, that's one thing. If you didn't get it in writing because they incorrectly or did not keep a record, well, that's in violation of their retention policy. That's something else. That's a different factor. So, and they're not required to give their calendars, which is interesting to me because we had this whole thing with the mayor a couple of years ago with regards. The mayor's required, but the supervisors are not in Prop G.
67.29-5 lays it all out.
You know it really
The
well.
mayor, the city attorney, and every department head shall keep or cause to be kept a daily calendar, et cetera, et cetera, et cetera. No mention here of the soups.
What are you looking for?
Sorry.
Oh.
One thing, though, is that I understand that we want the supervisors to be responsible to the Sunshine Ordinance. But, for example, that as Member Wolf was stating, 67.9 doesn't say it has to be the supervisors if it's available at the clerk's office. I mean, even as members of the task force, I know not all of us are totally careful about what documents we keep because we think we could call Chris. Hey, I lost this document. So, I mean, I don't want to continue it because I feel like there's not a lot that we can do, although I don't want to just leave it because it is a problem that's created. So if we don't write a letter or send them to the Education Outreach and Training, or perhaps we could request that they provide us with a signature stating, maybe we could, that they've reviewed the Sunshine Ordinance. I don't want to drop it, but I feel like we're not lie detectors. I can't stand up here and say someone's lying or not lying. This is about public documents. I saw them too take the documents, but if they're telling us they don't have them and they produced to you what they had, I completely understand. I sympathize with the complainant, but some of those are available at the clerk's office, and if they're not, that's a big problem. But we don't know because no one's gone to look.
Member Nee?
I'd like to call the question.
What's the question?
Could we have the motion read?
What's the last one?
Motion is to find violation of 21C.
No. That is not the motion that I have before me. Motion was to recommend to the task force that a letter go to the Board of Supervisors. Member Wolf made the motion. He will correct me if I'm incorrect. Regarding email retention and reminding the supervisors of their obligations under 67.21C.
Right.
Well, okay.
But I'll second that.
Okay.
Well, assuming it was seconded.
Moved and seconded.
Right. Mr. Clerk, would you call the roll, please?
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Washburn?
Aye.
Washburn, aye. Madam Chair, we have 5 ayes. The motion passes.
Mr. Clerk, would you call the next item on the agenda?
Yes, Madam Chair. The next item is hearing on the status of the May 24, 2011 order of determination of child spits against Supervisor Mark Farrell.
With the complainant, you have 5 minutes.
I think one of the differences between this one and the other one is I received even less information from Mark Farrell's office. I didn't receive any of the information requested regarding the calendars or the phone logs. Jane Kim sent like a big stack of emails, and Mark Farrell's, they only sent 1 or 2, where I believe when you look at the carbon copied areas that Mark Farrell received, like all of those documents that Jane Kim had sent, plus the other things that were received that I don't have a record of. I don't have. So I just received even less from Jane. I just received much less.
Thank you. Is there anyone here to present facts and evidence in support of the complainant?
Yeah, Thomas Piccarello. I was at both of the Rules Committee hearings regarding the Sunshine Monitoring Committee, Shelter Monitoring Committee, so I can speak as a percipient witness. Before I do that, let me anticipate what Supervisor Farrell's aide is going to tell you after witnessing what you did regarding Supervisor Kim, that they provided Mr. Pitts all the records that they have, and there's no further records. And so you're gonna send another letter to the supervisors advising them of record retention. Supervisor Farrell spoke with people regarding nominees for the Shelter Monitoring Committee. Supervisor Farrell met with applicants for the Shelter Monitoring Committee. Mr. Pitts requested records and communications regarding these discussions regarding the Shelter Monitoring Committee. Under the Sunshine Ordinance, he has a right to them. You need to question Supervisor Farrell's aide in regards to, did Supervisor Farrell meet with anybody? Did the supervisor talk to anybody? And if she answers in the affirmative, then you ask her, why didn't Supervisor Farrell produce the records pursuant to Mr. Pitts's IDR? Thank you.
Thank you. Is there anybody else with facts and evidence in support of the complainant? Okay. The respondent now has 5 minutes.
Good evening. My name is Catherine Stephanie. I'm a legislative aide to Supervisor Mark Farrell. First, I do want to respond that our response was not timely, and that is an administrative error that has been corrected. My colleague, Margot Kelly, is new and thought the immediate disclosure request was 10 days. We've promptly had an education with the City Attorney's Office on the Sunshine Task Ordinance, and that will no longer happen. We apologize for that. The request came in on March 21st at 3:43 through the clerk's office, and we responded on March 24th at 12:35. That response included 2 emails. What we do when we receive these type of requests is we do a thorough email search on all our computers, our Farrell staff email, my email, Margot's email, the supervisor's email. We also look in the cabinet area, in the Rules Committee area, where Mark keeps all of his documents related to the Rules Committee. We also do a search of our filing cabinet where we keep files. The only emails that we had when this request was made were the 2 ones that were provided to Mr. Pitts. I spoke with Supervisor Farrell about this. He did not have any meetings with anyone on the Shelter Monitoring Committee or anyone requesting to be appointed to the Shelter Monitoring Committee, and we have no calendar entries to reflect that because there were no meetings. So that's where we're at on that, and I'm happy to take any questions. And I know where this is going. We've just had this conversation, and I think, I've been working here at City Hall for almost 5 years now. I worked for Supervisor Alioto Pierre for 4 years before. I'm an attorney. I have a fairly good command of the laws as they apply to what documents need to be turned over. I think it's a lot of clarity that everyone needs around records retention. In providing documents to Mr. Pitts and preparing for this, I spoke with John Givner at the Deputy City Attorney's Office. I spoke with Madam Licavoli in the clerk's office. I spoke with Angela Calvillo, our clerk of the board, to get a better understanding of what type of documents do need to be retained, when they need to be retained, how long they need to be retained, and there really is no clear answer. I also think that people need to be educated that when something comes to 3 members of any committee, like the Rules Committee, and the clerk's office is not CC'd on that correspondence, that technically that could be considered an in seriatim meeting in violation of the Brown Act, and any emails or any correspondence that don't have a CC to either the clerk of the board or the clerk of the rules committee needs to be forwarded. I think that's a practice that I've always upheld. I've tried to. I'm not perfect. And I think that also applies to the entire board of supervisors. If you get an email, which we frequently do from members of the public on different topics, that go to all 11 supervisors and the clerk of the board is not CC'd, that then needs to be forwarded. And I can't tell you how frequently that happens, not just on a case like this, but on larger scale topics like Park Merced or something. So I think Ms. Johnson's recommendation of working with the Education Outreach Committee and I think the clerk of our board, Angela Calvillo, as to how to respond, because what I'm seeing here is something that is becoming so adversarial and accusatory when people are just trying to do their jobs. And it's unnecessary because people want to do their jobs well. I want to do my job well. I want to provide Mr. Pitts with all the information he requests. If I had known more at the time, I would have told Mr. Pitts that he could have gone to the clerk of the board and gone to Linda Wong, the rules committee clerk, and looked through the entire file. I would have walked him down there and shown him how to do it. And I want to do that as a city employee, as someone who works for my district supervisor. So I really think that this accusatory, adversarial feeling that I'm getting from sitting here is unnecessary. And I really want to work with you to make sure that moving forward, we have a policy in place where people know how to comply. And if I can help do that as a legislative aide, I would love to do that. So those are my comments.
Thank you. Is there anyone here to present facts and evidence in support of the respondent? The matter is now at the task force for discussion, comments, questions. Member Wolf.
Mr. Piccarello.
Yes, sir.
Do you have any information or evidence that Supervisor Farrell has had conversations with any of the applicants or anybody in discussion about any of the applicants?
Only hearsay, which is what the three supervisors used to deny Mr. Pitts the right to sit on the Shelter Monitoring Committee.
So you don't know, you only heard it from third party?
Yes.
Okay.
Hearsay,
Okay.
which is not credible or trustworthy.
Right. Okay,
Yeah.
thank you.
Yeah.
Ask your question, please. I'm not denying that you don't do your job. This is not about you doing your job. This is about a decision maker doing their job and how they make their decisions and who they're meeting with, not how a staffer is arranging to schedule a meeting or how they file a document or researching a document. What Mr. Pitts's complaint can be a quite serious one. And so it's really more a matter of speaking to the supervisor, him or herself, whoever that person may be, to find out if they, in fact, had any discussions with anybody. No notes could have been written. They could have gone out for coffee or what have you. But those communications, as far as need to be recorded. And that is what Mr. Pitts is asking for. So I'm going to ask the same question I asked the previous legislative aide, was there any communication logs kept prior to the Rules Committee meeting? And do you have those logs of any meetings about the shelter task force appointments?
To my knowledge, Supervisor Farrell did not meet with anyone considering the shelter monitoring committee task force. I'm happy to understand the hearsay behind it, and I'm happy to ask my boss whether or not he met with this person or people who are stating that they have had conversations with him. And if I have that information, which I don't have through all of this has been going on since May, not one person has come to our office and said, but you turn this over, and I understand that, Supervisor Farrell met with this person. Not one person has done that. And I'm happy to jog Mark's memory, or did someone come up to you in the hallway? We have no recollection or no prompting of that possibility. All we have
visitor log or anything like that.
We have a calendar. We keep a calendar. Okay. And despite what the statute says, every time we get a calendar request from Christian Homer, or we just got one from Chris Roberts at the SF Weekly, we don't say, we don't have to comply with that. We turn over everything. Mm-hmm. We turn over our calendars. And we look through our calendar when something like this comes across. And we had no meetings on the calendar. And sometimes in the calendar notes, it suggests what the person wants to meet with, when the person called. There was nothing in our calendar when we researched this request.
Okay, thank you.
Member Johnson.
I just wanted to say that on our agenda, on the full task force agenda in July, there's going to be an item to create a standing technology committee. And one of the reasons for it is to address these kinds of things about electronic documents. And, we never quite get, it's very late, and we never quite get a chance to have a detailed investigation or recommendations made. So I'm hoping that that would be something that would facilitate that kind of thing, even if it's to make, under the ordinance, we make recommendations about what would be appropriate. And, maybe the supervisors don't see what the public goes through, but we do. So I don't know if that's hopeful, but maybe.
Any other questions? At this point, the respondent has 3 minutes for a rebuttal. The complainant has 3 minutes for a rebuttal.
I'm just perplexed how I'm supposed to go into somebody's office with a number and getting documents that I'm requesting. I don't get that. I don't understand it. And she says everybody from the media and the press get a copy of the calendar, but when I ask for a copy of the calendar or parts of it, I can't get anything. So, I just definitely believe I've been stonewalled throughout this process. So Jane Kim sends some ambiguous emails. Mark Farrell sends something. Somebody else sends me a bunch of scribbles, and then now it's somehow my fault because I haven't taken some ambiguous number into somebody's office and asked for some documents. She said she would have walked me down there to go get the documents. I received no call from them. When I went to the Shelter Monitoring Committee when I went to the Rules Committee last time, they were very poignant and insistent that I pretty much did not exist. There was 3 candidates, and they said several times that there was 2 candidates, and one of them, it seemed like they listed who the 2 candidates were, just pretty much excluding me. So I've been stonewalled throughout this process. It's they aren't acting in good faith to get me the documentation that I'm requesting.
Thank you. The matter's back with the task force. Member Johnson?
I would make the same, put it under the same umbrella as the case with Supervisor Kim to make sure we give them equal treatment as they seem to be of similar situations where they're saying that the document doesn't exist.
Is that a motion?
Yeah, I'm not sure how to make, motion to refer it, well.
Member Snyder?
I think the prior motion, which we passed, was to send a letter to all of the supervisors regarding this issue. So I don't know if there, I mean, is it necessary to do another one? I think that.
Perhaps we could label it same house, same call.
We'll do it a la David Chu. Sorry, Catherine.
Okay, so it's essentially the same motion as before to apply to this, but I think we need to have it be in our minutes as such. And I need public comment on this motion.
As I listened to the two legislative aides report with great sincerity how they were so careful in going through records and determining that there were nothing to be found in response to Mr. Pitt's requests, I ruminated over my own experience, which I think is probably much the same, which is you can send the letters, but these things are going to happen in the halls or over coffee somewhere. And it really goes to a different issue, which is the quality of the supervisors, you know. The difficulty in getting honest political representatives, and that ain't easy. I met with Mr. Farrell, but I didn't meet in his office. His aide arranged for me to meet him at a cafe on Chestnut Street. I don't know what he reported when he got back. I met with Jane Kim's other legislative aide several times. And I don't know if that was reported or recorded. But what I do know is that the decision with regard to my possible appointment was made not based on the interviews, but it was made by the 3 members of the Rules Committee and probably 1 or 2 other supervisors who had other agendas. So as much as I would, favor your sending the letter, I wouldn't waste a lot of time on it because I don't think it's going to make a heck of a lot of difference. Thanks.
Thank you. Is there additional public comment?
Thomas Piccirillo.
You were a witness.
Oh, right. Yes.
This is public comment on your motion. I think I have a right to do that, and I'll challenge you.
No, you presented facts and evidence.
This is what we do in every single...
Sorry?
You were a party to this complaint. You presented facts and evidence in support of...
I'm not allowed public comment
No.
on the motion that was just made?
No. No.
Because you were a party to the...
Member Wolf?
I just want to say in my own experience, on behalf of Mr. Grossman, I spent numerous amount of hours roaming these halls in, I'd say, probably 8 or 9 offices and trying to get him support for the Ethics Commission appointment. And I didn't make an appointment because I know many of these people, or I just happenstance walked in or happened to see this supervisor in the hallway and walked that person to the bathroom or to the vending machine or to what have you to have the discussion with them. There's nothing written down. If you asked them, they probably would say, yeah, I spoke to Bruce about it. But this is politics. This is the core of politics. And politics, when it comes to politics, lots of times that there is no paper trail. And there's a verbal trail, possibly, if they want to admit it. And I'm not saying that I'm not saying anything about this particular supervisor or any other particular supervisor, because it's usually on a case-by-case basis, or any other person. But that's just the way these things go. And it's unfortunate the way those things happen. I think what's more important is what the documents that were distributed during the meeting that were not then distributed, were only distributed to the members of the committee and not distributed to the members of the public. I think that is more important, and that should be focused on more. I think there possibly is a lot of information in there that Mr. Pitts would like to see. Otherwise, it's really hard to compel. I remember trying to get the then Mayor Gavin Newsom, trying to get his calendar was really, really difficult. But when the fire chief came, it was easy. So, it all depends upon the person and what they're either trying to do or not do, or protect or not protect. But in this particular matter, it is a matter of politics, and I think it's just really hard. It's really hard to track down the smoking gun, if there is one. That's it.
Member Johnson.
I'm sorry to take up more time, but I just quickly have to say this. I went through with all of the remarks that are going around. For those of you who don't know me, there's a number of the supervisors who don't even look at me from all of the things that have gone on. And in light of what Member Wolf has been saying, there's a lot of people that I've lost a lot of respect for. And even though we're not on the same necessarily page all the time, Catherine, who's here for Supervisor Farrell, is not one of them. She is a very upstanding person. And that's coming from someone that's really hard for me to say about a lot of the people that are here. So if you, Mr. Pitts, really feel something, I think that that's a credible place for you to ask a question. And while no one is going to be perfect, and I can't vouch for every single thing that these people do, I don't want to just sit here and lump a big blanket on her. I went through the DCCC election, and she was also a candidate, and that was pretty grueling. But I saw a lot of things. So, I encourage you to use that as a resource. So I don't want to lay a blanket statement down like that.
I also wanted to state that Catherine, I can't remember your last name. Stephanie, okay. You raised a number of issues that you see as potential problems regarding sunshine. And I don't remember all of them, but the fact that the clerk of the board isn't often CC'd on emails and that sort of thing. And you raised a lot of important issues. I'm wondering if we could create an opportunity to discuss these things further and do some brainstorming about how to help all of you comply more. We'll learn more. I mean, I think this is a great opportunity, and I think it might be something that the EOT could take on. And so, Chair Johnson, I just wanted to suggest that that we look into this. I think there's a chance to do some good here. So thank you very much for your ideas. Member Wolf.
I'll wait till announcements.
Okay. Let's see, where are we? We have a motion, and we've heard from the public. Mr. Rustin, would you call the roll, please?
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Washburn?
Aye.
Washburn, aye. Madam Chair, we have 5 ayes. The motion passes.
Mr. Clerk, could you call the next item on the agenda?
The next item on the agenda is the next steps on Ethics Commission proposed policy for handling sunshine-related complaints.
Madam Chair.
Member Nee?
At the risk of incurring the wrath of everybody in this room, I'm going to move to continue this item. The reason is that the information packet is incomplete. You will note on page 57 of our packet, it says Attachment A and Attachment B. Those attachments are not included. They are probably not included in the packets that's available to the public either, and therefore I don't think that it would be a good idea for us to move on this tonight.
I agree. I had to go searching for the documents at home, and
And I would ask that when this is rescheduled, that the clerk make sure that everything that needs to be included is.
Member Johnson.
I am,
Point of order. Is there a second to my motion?
sorry about that.
Second.
Member Johnson.
I have a question. Are you saying to kick it to the next Compliance and Amendments Committee?
Yes.
Because I'm going to suggest that we put it on the full task force agenda. I do not want to wait until August. I mean, we were, after yesterday's Ethics Commission, I don't know what you think about that.
No, I tend to agree because we have, our committee has discussed this quite a lot. We asked Mr. Grossman to write a covering memo, which he's done, circulated to us. Actually, the changes in, recommended changes in the regulations were a part of the packet last month. You know, I think we had decided what we would be doing here actually was thinking of next steps on how to move this forward. I don't think there was we weren't planning to vote on anything tonight. There wasn't anything to vote on. We'd already said, yes, these are the changes we want to see, and they've been very well explained in Mr. Grossman's covering memo. We need some sort of a cover letter, and we need a plan. So I think we should take it up at the full task force meeting and not delay anymore. It's getting embarrassing.
Without
frankly.
recommendation?
Well,
Member Nee?
yeah, I'm certainly amenable to that. If that's an amended motion, I guess, and the maker will certainly accept if the second will.
I will.
And I'm perfectly happy to have this go before the full task force. I agree, it shouldn't wait till August.
Okay.
And the sooner we can move on this, the better. Although I will add that it's still going to be the Compliance and Amendments Committee that conducts the joint meetings with the Ethics Commission. At least that was the original plan,
Right.
unless we want to change it.
No, that seems manageable. Public comment on the motion before us?
I'm a little punch-drunk. I wish Mr. St. Croix had not made a snide comment about the fact that we had been waiting since last August for this stuff. And if you go back, and we can't go backwards, but obviously there were times when we could have gotten this done quicker, but for reasons that apparently nobody could control, it could not be done. But I wouldn't, you know, if you need a special meeting just to do this, then you could do that very quickly, it would seem to me. And I don't know. I would just redate everything, because right now it's all dated in June, so you may want to redate it currently. Thanks.
Thank you. Is there additional public comment on this matter?
Thomas Piccarello. Yeah, this thing has been dragging on far too long. And I don't want to defend Mr. St. Croix, but he is accurate. You've had this matter in front of you since August of last year, right? At least. So you need to push this thing. You need to make decisions and finalize. But I'm troubled by you putting this on your next Sunshine regular task force meeting, because you're going to have a full agenda there, and you're not going to really have an opportunity to discuss the issues that should be presented. My suggestion is you have a special meeting in a couple of weeks, and you just devote your full attention to the matter on the agenda that you're now continuing again. Thank you.
Thank you. Additional public comment? Member Wolf?
I might like to offer either a friendly amendment, or if not, make a motion, substitute motion, to leave it at the discretion of the chair to determine how to dispose, what we should do with this next, whether we should have a special meeting very, very soon, move it to the next meeting, or what have you.
Which chair are you referring to? Yeah.
The chair of the board.
You know
chair
you know the upcoming agenda, and I don't, so.
I haven't actually seen the full upcoming agenda, but I'm a little bit reluctant to. I sent out an email about this before. I'm a little bit reluctant to continue with these special meetings. It's real hard on me, so I imagine it's kind of hard on the public. What it creates to me is the impression that if you show up at the regularly scheduled time, you will not be able to participate unless you can then show up at a special meeting, because there's the possibility that I might not be able to show up at a special meeting. It's difficult for me to leave work regularly early. I imagine it might be difficult for Member Snyder as well. So that's my concern. If you feel like you have to have a special meeting, part of what goes on is that we complain that the Ethics Commission won't enforce. So I could just say put this off to a special meeting and then have run through that agenda on the task force and have nothing be enforced and have no appropriate regulations. So to me, this is pretty urgent because we could keep referring to them. We also have a problem now, and that's because, we just referred Mr. St. Croix to his own ethics commission. Now we're going to ask all of them to meet with us. So, if there's a quorum and you feel like you can have a special meeting and you feel like a quorum can get here, perhaps.
The only reason why I would hesitate having it at a full meeting is, if you remember the last meeting, we had to end before we had a number of items still pending. I had items I wanted to express during announcements, never happened. And that happens most of the time. So unless you want to put this as the very first item and make every complaint wait.
Well, what is it that you're waiting through? I mean, we already approved that that's what we would send, and then we were going to have a cover memo put over it.
Well, then why is this on today's agenda?
Well, because we were not necessarily going to give it to the full task force.
We're not going to.
Right. We were going to talk about.
What more is there to talk about?
We were going to talk about our strategy for taking this to the Ethics Commission. We also had Mr. Grossman's covering memo to, say yes, this is fine, but it was my understanding that it was mainly, okay, how do we move this forward?
Don't we just send it to him?
Well, I think we have to be really politic about it, the whole thing, and figure out how do we, given what's going on with the civil grand jury and what we did tonight, how are we going to make sure that we have a fair chance of being heard and being able to negotiate something that's going to work? Otherwise, what in the world have we been doing? So just simply sending it to them isn't going to get us very far, I don't think. Member Nee?
Let me make a suggestion. There is a motion on the floor to send this back to the full task force for a sign-off, basically. Mm-hmm. After that, we send that we've already, I think, given our approval to the cover letter that was developed by Mr. Grossman, to the draft that was prepared, to the actual draft of the substance that was prepared by Mr. Grossman. We've already given thumbs up to those.
Yes, we have.
I think this memo was in front of you, though, right?
That memo was in front of us it was in front of us last month, and we couldn't move on it because there was no quorum. But if we put the appendices and the cover letter, which is the memorandum, before the full task force, we get the full task force to vote it up or down or change it. You know, I guess we're treading on dangerous waters here because somebody on the task force may decide it needs further tweaking. That's a risk we take. But at this point, I think the best thing to do is take it to the full task force, see if we can get them to sign off on it, to give it a thumbs up. We send it forthwith to the Ethics Commission and say, you know, the Compliance and Amendments Committee would now like to arrange a joint meeting with the Ethics Commission to discuss these matters in full. And we contact them and set a date. I think we're at that stage where we can do that now, and I believe Member Wolf had some comments.
Member Wolf?
I would just like to say if the next full task force meeting is August 23rd, I will be out of town.
Next full task force meeting is July 24th.
Oh, July 24th.
Or, no, 26th.
Okay, I'm sorry. That's right. I will be there, not in August.
Try to set up a special meeting, but I don't know.
Oh, Member Snyder?
I was just going to say, I think a special meeting would probably fall after that anyway, right? It's not like it would be any faster because we have to have a certain amount of notice for a special meeting. I think the full task force meeting would probably come first. Yeah.
Mm-hmm.
So it's not any faster to do a special meeting.
Is it point of order
12.
question?
You got 2 weeks.
Member Johnson?
Next week. Yeah, but you could do a special meeting next week.
Member Johnson?
Well, if you can arrange a special meeting and you could get a quorum there, you could try that. Although I don't know if here we could. I have 2 point of order questions. If you try to arrange a special meeting and it doesn't work out, does that mean we would be unable to put it on the full task force agenda if we don't decide that here today?
You put it on both. And then if it doesn't, if you do it, if you have the special meeting, then you just
take it off.
You take it off the agenda for the next
So
one.
there is the possibility that we could put it on both. We could try to schedule a special meeting.
Of the full task force?
No, of the compliance and
Special.
amendments, a special meeting of compliance and amendments. We put it on both agendas. And then the other point of order question is, can this be posted to the public and sent out to the members of the full task force early
I don't see why not. It's been
so
part
that
of our
they have
agenda.
ample opportunity to look at it?
Absolutely.
Yeah. It already, and it more or less has been. It's been on every one of our agendas.
Well, but to everyone on the task force? How would we post it for the public?
Member Nee?
Send it to all of us through the clerk,
And you post it?
and ask that it be publicly posted as well. Once it goes to the clerk and it's sent to us, it's public information.
Does it
So
have
we
to be
would-
sent to the service list also?
Chris?
Through the chair, the simple question is, I can post it on the website.
So then we could amend the motion to include it potentially on a special agenda, but on the task force is full, so in case it doesn't go through, the special meeting doesn't work out.
Okay, so the amended motion is that this matter be continued to a special meeting, or the next.
Well, but whichever should come first.
Special meeting or the full task force if the special meeting doesn't take place.
And of course, that
How about a special meeting of this committee or the next regular meeting of the task force, whichever comes first?
Oh, excellent. Okay. Second? Does the second approve?
And
Okay.
are you okay with trying to arrange a special meeting?
Yes.
Okay.
Chris can poll us members. Public comment on this amended motion?
I'm almost speechless, so you can imagine. With all due respect to the five of you, I don't understand why you can't get three of you together at 6 o'clock one day next week, to at least three of you, to do what's necessary. And the other thing I want to point out is that if you go back and look at why we are here today talking about postponing it again, it's because of individual choices, not the group, to do certain things or to not do certain things or to not do their job. And I think it is a reflection on the way in which the task force is served by the administrator and by the fact that it's 11 people, and when you have 11 people, when somebody thinks they don't have to go, they won't, because they know there'll be 10 others. But when you consider the fact that enough people, enough of the 11 don't show up, you end up with 6. And then you get people like Mr. St. Croix who can start poking holes in what you're doing because of that. And, you know, it's easy for me to say, you know, I'm not sitting there, and I'm not spending the long hours that you are at the meetings, although today is right up there. But I do have a sense that the commitments are really important, and it's important that you have a strong staff, very strong. Thank you.
Thank you. Is there any additional public comment? So, Mr. Ruston, could you call the roll, please?
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Wolf? Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Washburn?
Aye.
Washburn, aye. Madam Chair, we have 5 ayes. The motion passes.
Mr. Clerk, could you read the next item on
The
the
next
agenda?
item is the Administrator's report. Madam Chair, I do not have anything to add.
Is there any public comment on the Administrator's report? Okay. Are there any announcements, future agenda items? Member Wolf?
I just wanted to say that with regards to supervisors' emails and the kind of the notion that Ms. Stefani had made regarding emails that are sent to all supervisors but not to the clerk, that maybe all emails should be automatically CC'd or blind CC'd to the clerk through the city's email system, so that she has a copy, you know, that it works that way. I mean, you know, it's a kind of an enigma, because, you know, the clerk thinks about things as a system. It's the board. She serves the board. She doesn't serve every individual member. She serves the board. And that's the way the conversation always goes with them. So, you know, they treat it as a department versus each and every individual member. What each and every individual member does, that's what they do. That we're not in control of that. That's basically a response. So if there is concern about that with regards to email, maybe that's a suggestion we take up at the technology committee upcoming.
Member Nee?
Yeah, I'm thinking that one response that the clerk might give to us on that is that if they're blind CC'd all the emails, their storage space on that might fill up rather quickly.
There is unlimited storage space
Okay.
in the
We
city.
can, we can argue that with them, but I'm just saying we may have that go around.
Yeah, that's fine. They have a retention policy. They can start deleting things, making room elsewhere. Anyway, just a thought. I don't know.
Do I hear a motion to adjourn the meeting?
So move.
The meeting is adjourned at 8:41.